May I please also? With regard to item number 9 of today's list, my lord, I'm taking some accommodation in that matter.
What accommodation?
My lord, I'm led by senior counsel, Mr. D.K. Mishra, in this matter. He has another hearing matter in court number 1. He's not keeping very well, my lord. He is coming online. The matters might clash, my lord.
So you want an
For today only.
adjournment?
Adjourn.
You have informed the other side.
My lord, I'm there for that.
You have no objection. Heard Mr.
Be present.
B. Prashad, learned counsel for the appellant.
Petitioner.
Learned counsel for the petitioner.
Item 9.
Also heard Mr. A. Sahiwala, learned counsel for the respondent. Learned counsel for the petitioner seeks an adjournment for today only, to which the learned counsel for respondent does not raise any objection. Hence the prayer is allowed.
May I please, Lord? My lord, I'd like to mention item number 10, my lord. With the consent of the other side, I pray for adjournment and the matter may be taken on 6th of November, my lord.
No fixed date.
At least, my lord, 13 November, my lord.
You are respondent.
Yes, my lord. I'm
Heard-
all the respondents.
Heard Mr. K.U. Ahmed, learned counsel for the respondent, who seeks an adjournment on the ground of personal difficulty of the conducting counsel. He submits that he has informed learned counsel for the appellant regarding his prayer for adjournment, who has no objection to the same. Hence the prayer is allowed. Registry will fix the date.
13, my lord, or 20, my lord. 6, 13, 20, my lord. 18.
November.
My lord, yes, my lord.
Okay, 20 November. This matter.
Obliged. Please,
Yeah.
appellant is there.
I am for the
Sure.
Obliged.
Show the presence of Mr.
JM Google.
J.M. Gogoi for the appellant.
May I please, your lordship? Lordship, with due consent from the other side, I beg to mention item number 7 of today's list, lordship. I appear for the appellant, lordship. We want an accommodation for today itself, lordship. It may be taken up any day next week, lordship.
It will be not possible. Heard Miss
A Chakravarti.
A. Chakrabarti, learned counsel for the appellant, who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the appellant. She submits that she has informed the learned counsel for respondent regarding her prayer. You are present. No. He line to Katedibo. Also at Miss, what is your name? S.Todi.
K. Bhattacharya.
K. Bhattacharya, learned counsel for respondent. Who, respondent number 1 and 2, who does not have any objection to the said prayer. Hence the prayer is allowed. Let this matter be listed in the 3rd week of November on a date to be fixed by the registry.
Obliged.
If I may, my lord, I beg to mention item number 13 of the daily list.
Item number, be louder.
13, my lord.
13.
Yes, ma'am. My lord, we have taken consent from the other side. I'm appearing on behalf of the petitioner.
Heard Mr. G. Imtiaz, learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty.
Yes.
He submits that he has informed learned counsel for respondent regarding his prayer for adjournment, who has no objection to his prayer. Hence the prayer is allowed.
Deeply obliged.
May I please, your lordship? Beg to mention item number 5, your lordship. I am appearing on behalf of the appellant. The counsel Ms. K. Yadav has recently gone hip ball surgery, your lordship. 2 weeks back, she has been advised bed rest, your lordship.
Okay.
Some accommodation.
You have
will be granted.
informed the other.
Please
They
for the
have
others.
informed us, but no consent was not given, my lord. In this matter, learned counsel, Mr. P.K. Rayachowdhury has been engaged, my lord. So when matter will be called, my lord, my senior will appear and then accommodation may be made.
Okay. let the matter be called for.
Obliged. Obliged.
Item one.
Yes, your lordship.
Also, case lordship notice may be issued.
Also, why it has come to this court? Second,
No lordship.
third, Miss, what is your name?
Chanda.
S. Chanda, learned counsel for the petitioner. Also, Mr. B. Sharma, learned additional public prosecutor. It is a pending investigation case.
Yes.
Let the case diary be called for. Let also notice be issued to respondent number 2 in pursuant to the prevailing notification of the registry in this regard. The petitioner shall take steps for issuance of notice upon the respondent number 2 within 3 days from the date of this order, returnable on when
Your lordship.
returnable on 12th, on 30, sorry, on 12th of November. Please check on. Yes. October. Have you appeared?
Your lordship, I have already appeared on 25th and today also is on his way to the police station. He has reached the police station.
Yes, instruction.
Which is the whole premise.
Case diary is there.
Yes, yes, yes. The whole premise of granting the interim lordship was only on medical ground. Lordship, I have carefully gone through the video footage of that day also, lordship. On that day also, they had specifically stated, lordship, that was their submission that I have no merit in the case. I am just submitting on the grounds of medical emergency. I may be protected for a few
Not medical, funeral.
Funeral, yes, I'm sorry, funeral. That was the specific advertisement that they made, lordship. Now, lordship, on that regard and in that interim order, lordship, you kindly see, they were directed, specifically given the direction to appear on 30. If lordship kindly.
30 today.
Yes, your lordship.
Only today, lordship. And if I remember correctly, they also made that clear that I can appear before 30 also. Then also lordship said, no, you appear on 30. That was the specific direction, lordship. And it also reflects in the order also, lordship. Be that as it may, lordship, they appeared on 24th before the IO. And statement was recorded, lordship. Evasive answer. I'm not going on to all those things. Now,
Now, do you require his
yes,
detention?
lordship. Case is pending against him, lordship. Investigation is still going on. It is the instruction that I have received from the IO. So it is the situation.
No, but why do you require his reason?
Yes, lordship. The reason, lordship, is lordship, the victim girls. There are some more victim girls, I have been told, lordship, and investigation is going on in that regard.
No,
But
but
at first-
investigation has been otherwise completed in respect of other.
Yes.
And
already
charge sheet has been
charged.
laid.
Yes, yes. That is true, lordship. But on the other hand, lordship, the custodial interrogation, in my respectful submission, is not the only consideration, lordship, for anticipatory bail, lordship. Here, lordship, this bail was rejected on twice, lordship, if I'm not wrong, and all detailed observation has been
No,
given
no.
to them.
Why, what I fail to understand.
Yes.
When the investigation was going on, no protection was granted to the petitioner.
Yes,
You failed to arrest him. Police failed to arrest him and submitted charge sheet without showing him as an
that's one.
as an charge sheeted accused,
Yes.
though there were materials against him at that point of time also.
I agree on that, because they could have, Lordship, charge sheeted against him also, Lordship. That is true, Lordship.
Now suppose now you have not yet filed charge sheet against him till date.
Yes. Yes. I've been told, Lordship, it will be filed very shortly, Lordship. Just a few more aspects to be done into. Charge sheet will be filed shortly. I am submitting, Lordship, on the basis of the grant of anticipatory bail, which I have already pointed out, Lordship. It was not given on merits, just for final verdict. So that does not give him any right. That is my first submission, Lordship,
Yes.
for grant of anticipatory bail, final anticipatory bail. And Lordship, the other aspect is, Lordship, regarding the severity of the offense. That
Oh,
also, Lordship, will have to
okay.
take into.
No,
consideration.
otherwise also interim bail was granted for a temporary period
Yes.
for a specific purpose.
Specific purpose. And that too, a specific direction was given to
Okay,
appear him on 30th, Lordship. That is my respectful submission.
then you surrender, Mr. Singha.
Your Lordship, at the end of the day, whatever direction comes from your Lordship. But just to rectify few of the points, as my learned friend has just presented before this. Your Lordship will kindly turn to page 65 of my bail petition.
No, whether you have performed all the
Exactly.
rituals are over.
Yes. I am not here to say all those things, only to one of his points, your Lordship,
Page number,
65. Your Lordship remembers that an earlier round of litigation, two accused appeared and we said that the charge sheet was filed. Then your Lordship has directed us to appear before the court below and to apply for the regular bail. So while praying for those bails, a detailed consideration was looked into. The entire record was before the honorable court. Now this is the finding. A bare perusal of the statements of the said victims, women's girls, except one, also reveals that they are aware of and involved in such activities since long, that is more than a year or so, and they do so for money. Moreover, one of the victim women girls, such and such, has also stated when she stated that to one of the customers. I don't want to read the other persons. Now the next line. Charge is yet to be framed and the trial is yet to commence. It is relevant to mention here in the charge sheet that in the charge sheet 28 prosecution witnesses have been cited. Considering the above facts, including the nature of the materials on record as discussed and also the fact that the investigation is already complete, this court is of the view that further detention is unwarranted. Your Lordship will pause there for a moment. My friend has just now said that some more victims.
unwarranted in respect of which
Yes,
accused?
exactly. Now I'll come to that. I'll not skip that. Now my learned friend has said that some more witnesses' statements are to be there, some more victims are there. So why it was not stated before the court then? And who are the victims? I can understand that, your Lordship. If there would have been some victims who are on the run, who are on the chase because of the fear psychosis created by me, if at all, your Lordship will see there is no way of tampering with the evidence. There is no way that I will be required now for further custodial interrogations. I am cooperating with the investigations. I have gone.
No, where is your rejection order?
My bail rejection order, your Lordship?
It is anticipated bail.
Yes, your Lordship. On one occasion, it was rejected by your Lordship, that I have annexed. But what I'm trying to say is that already statements are recorded. I am available now. They can find me anywhere. Now they said that more witnesses are there. Who are those witnesses? Have they named it in the case diary? Simply making a statement, your Lordship, will not suffice the thing. Have I violated any terms and conditions?
No.
I understand that.
You obtain bail on a specific ground
Exactly, your
for a
Lordship.
specific purpose.
Right, your Lordship. I
That
agree to
purpose
that.
is over.
Right, your Lordship.
So you no longer is entitled to.
I appreciate your Lordship will see the changed circumstances as of now. I'll leave it to your Lordship. But what my learned friend has just now submitted, that there are more witnesses and therefore my custodial interrogation is required. Nothing is more remained, your Lordship. Every victims or witnesses, whatever are there, They have been examined.
No.
Their statements were recorded,
Your one anticipatory bail application was rejected
rejected,
earlier.
your lordship.
So second is maintainable only if some new grounds.
I appreciate that, your lordship. The new ground is that as of now, right now, your lordship, the new ground is that have they found anything threat perception from my part, or is there any complaint against me that I have threatened somebody? There is nothing. What he is submitting is just contrary to what the actual position is, your lordship. Your lordship will kindly examine the position and the stand as on date. I am not opposing.
I'll come to you. Let him complete.
Yes, I am not opposing to what he's saying. But what I'm trying to say is that it is totally contrary. It is not matching with the records. That some more witnesses are there. And the earlier bail which was rejected, your lordship, that is at para 19. If your lordships kindly turn to that. Order to. Para 9. Don't know why. If your lordships kindly come to page 30. Para 19. The investigation of the case is still at very early stage, and in view of the incriminating materials found in the case diary against the petitioner number 2, the court is not inclined to grant anticipatory bail to him at this stage. Your lordship, the investigation is page 30 of my bail application.
This is the earlier rejection order.
Yes, your lordship, it starts at page 27, the operative portion, but the ground for rejection is at page 30, para 19.
Yes, investigation is still going on.
Is still at the very early stage and in view of the incriminating materials found in the case diary. Now, your lordship, the investigation is completed.
Not against you. It is pending, still pending against you.
Your lordship, whatever they have to collect, they have collected. I have gone, today also I have gone. They may record my statements already recorded, and today also they'll record or whatever they think fit. Is there anything left thereafter when I am available? When there is no complaint against me, there is no complaint against me for threatening any of the witnesses or have violated the conditions of the bail during this period? Or does it reflect from the case diary that such and such person, named such and such persons, has yet to be examined? Or it is their case? Your lordship, that is not the case. The situation has changed now, as on date. That is my fair submission. Rest I leave it to your lordship.
Yes.
If I may just clarify one thing, Lordship. This very foundation of the argument is erroneous, Lordship, because Lordship, the order that they have shown at page 65, it is a specific order based on the bail application filed by the co-accused, Lordship, who have already been charge sheeted, and in respect of them, the charge sheet was filed. And the investigation so far, this petitioner is concerned, is ongoing. And based on that surmise only, Lordship had granted him interim protection. Because Lordship, on that day also, Lordship, when the Lordship realized that investigation was pending against him, only that granted him the interim protection, Lordship. Otherwise, he would have been in the same page, Lordship. Now, Lordship, the charge sheet has been filed against the other co-accused. Against him, investigation is still going on, Lordship. There can be more evidence, Lordship. Does it prevent the IO from investigating other victim girls, Lordship? It does not, Lordship. Investigation against him is still pending. Only on that fact, Lordship, the interim protection was granted because investigation was kept pending against him. Otherwise, he would have been treated on the same par with the other co-accused, Lordship. And this observation that he has pointed out at page 65, it relates to the other co-accused, Lordship, not the present petitioner. He is not a party to this order also, Lordship. That is my respectful submission, Lordship.
Your lordship, that observation was in respect to the entire schemes of the things, entire records which is before the court. And your lordship, whatever incriminating materials they are to seize, they have seized from the place. In fact, I was not named in the affair. I was said by somebody that such and such persons involved. So for that reasons, the witnesses, the affected parties, the victim girls have been examined. There is no element of threat from me. I have cooperated with the investigations. Your lordship will appreciate the fact that when everything is before, why they want my custodial interrogation?
No, after Mr. Sharma, after he appeared on 24th,
24th,
Oh,
25th, your lordship.
25th, his statement was recorded.
Yes.
Thereafter, what is the endorsement of IO? What IO has stated? Does he require further?
Endorsement to that effect is not their lordship, but he has stated that further investigation is required.
Okay.
Further investigation is required. Custodial interrogation is not
Heard
required.
Mr. R.
And your
Sinha.
lordship kindly note that it has not stated that some more witnesses or victim girl statements have to be recorded.
Okay.
That is my
Heard Mr.
submission.
R. Sinha, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioner, namely Pawan Kumar Sharma, who is apprehending his arrest in connection with Sonapur PS case number 113/2025 under section 143/317 within bracket 4/49/3 within bracket 5 of BNS, read with section 14/15/16/17 of the Assam Games and Betting Act. Stop. It is pertinent to mention herein that and the petitioner had approached this court on an earlier occasion by filing an anticipatory bail application during the course of investigation and this court had rejected his prayer for anticipatory bail in AB case number 1786/2025 on the ground that there were sufficient materials against him in the case diary. Stop. In the meanwhile, the investigating officer laid the charge sheet against other co-accused persons and seeking leave of the trial court to continue further investigation against the present petitioner. One of the reasons mentioned in the charge sheet for not submitting the charge sheet against the present petitioner along with the other co-accused is that at that point of time he could not be detained. Stop. It is further pertinent to mention herein that on 14/10/2025, the petitioner was granted interim bail on the ground that his mother had expired on which date? On 12/10/2025, and the petitioner had to attend the religious rituals to be performed of his deceased mother. And accordingly, this court, by order dated 14/10/2025, had granted interim bail to the petitioner to enable him to attend the religious rituals of his deceased mother. It was further directed that the petitioner shall appear before the investigating officer on 30 October 2025. That is today. Stop. Learned counsel for the petitioner has submitted that though the petitioner was directed to appear before the investigating officer on 30 October 2025, However, he had approached the investigating officer on
25th, 24th.
24th October 2025. And on that day, his statement statement under section 180 of BNSS was recorded by the investigating officer. It is submitted by learned counsel for the petitioner that today also the petitioner has already reached the police station to appear before the investigating officer in pursuant to the directions of this court. And he is ready to comply with any condition and is ready to cooperate in the investigation. Stop. He therefore, learned counsel for the petitioner therefore submits that though the interim bail therefore submits that the interim bail granted to the petitioner on 14/10/2025 may be made absolute, subject to any condition which may be imposed by this court. Stop.
Your lordship will, sorry to interrupt your lordship, one more thing. On the last date when your lordship granted me the interim protection, there was a 3 direction your lordship has directed. Those directions were also complied with and there was no violation of those directions.
Learned counsel for the petitioner further submits that the interim bail was granted on 14/10/2025, to the petitioner on by imposing certain conditions, and the petitioner has abided by all the conditions so imposed. He further undertakes to comply with any condition which may be imposed if the interim bail is made absolute. On the other hand, learned additional public prosecutor Mr. B. Sharma has produced the case diary of Sonapur PS case number 113/2025 and has submitted that though the petitioner had appeared before the investigating officer on 24/10/2025. However, and though the statement of the petitioner was recorded under section 180 of BNSS, however, there are still some other witnesses/victims who are required to be examined. And if the petitioner is allowed to, if the interim bail of the petitioner is made absolute at this stage, there is a possibility of influencing those witnesses by the petitioner. He further submits that the interim bail was granted to the petitioner for a specific purpose, and when the purpose is achieved and when he surrenders before the investigating officers in pursuant to the said direction, there may not be any reason for extending or making the said bail absolute, interim bail absolute, as this being the second anticipatory bail, the petitioner has not shown any new ground for making the bail absolute. I have considered the submissions made by learned counsel for both sides. It is true that the interim bail was granted to the petitioner under peculiar circumstances, that is due to demise of the mother of the petitioner. The interim bail was granted mainly to enable the petitioner to attend the post-death rituals, religious rituals of his deceased mother. However, in the meanwhile, it appears that the petitioner had appeared before the investigating officer even prior to the date on which he was directed to appear. And the investigating officer had also has also recorded the statement of the victim, statement of the petitioner under section 180 of the BNSS. Stop. Though learned counsel for the learned additional public prosecutor has submitted that there are some more victim girls to be examined. However, in the case diary, there is no indication by the investigating officer as to whether, in view of the cooperation rendered by the petitioner by appearing before the investigating officer, his custodial interrogation would be necessary for fair completion of the investigation in respect of role of the petitioner in the offense alleged in this case. Stop. Considering the fact that the investigation in respect of other accused persons have been completed and charge sheet has been laid, and the accusation against the present petitioner is also of the same nature, and also considering the fact that the petitioner has appeared before the investigating officer and has rendered cooperation, and there is no indication in the case diary regarding requirement of further custodial interrogation of the petitioner, this court is inclined to make the interim bail granted to the petitioner on 14/10/2025 as absolute on following terms. The number 1, para number 1 and 2, following terms. This anticipatory bail application is accordingly disposed of.
Your lordship,
Send back the case then.
your lordship may I just make one more to be fair enough. Let his passport be also deposited, so that there is no chance. At least I want to ensure to be fair to the court.
So I should include that condition.
Let it be, your lordship, then that will be there also satisfaction. Nobody will be prejudiced in that case. If they are anticipating something that I might abscond or something like that.
No. Had I believed them, your bail would have been cancelled.
No, your lordship, to be fair, anyway, I leave it. I am deeply obliged, your lordship.
Here, lordship, I have a small clear lordship. Miss M.K. Brown is the appointed amicus lordship. I have been informed by her lordship that she is unavailable today. Lordship. So she has prayed that the matter will be taken up on third lordship.
Third. Okay. Third, Mr. S.H. Sigdar. Yes, Mr. Sigdar. S.H. Sigdar, learned counsel for the petitioner. Also, Mr. B. Sharma, learned additional public prosecutor, who submits that he has been informed by learned amicus curiae that due to some personal difficulties, she is unable to attend the court today. And on that ground, an adjournment is prayed for. The prayer is allowed. Let this matter be listed on 3rd of November.
Actually, she is engaged in some other court lordship.
No, that may not be a proper ground.
Possible. they will be involved in a cross lottery, so it may take some time. So
Okay,
Because my lord,
okay, no, third, let us
Right. Right.
fix it on third.
public.
Yes. You have completed your submission,
No, no, I have to
still there,
further hearing it.
okay.
May I present? My lord, here-
Basically, this appeal is under Order 43, Rule 1R. That the trial court did not grant you ad interim ex parte injunction,
Yes, sir.
but it did not refuse their injunction.
No.
Now they have appeared.
Ye-
You can argue your case before the trial court and let the trial court decide.
No, Lordship, I am aggrieved by the impugned order as because Lordship, there are MU was executed between the parties, both the parties, Lord, by which the dispute was completely settled by MU dated 23rd of September to 24. So thereafter, Lordship,
No, but the trial court did not rejected your prayer.
trial court Lordship, in the plaint, I have taken a specific plea regarding the MU. Lordship, may be pleased to come to the MU averments made in the plaint, Lordship, page. Lordship, that the learned trial court did not discuss anything, not a single whisper. Lordship, may be pleased to take up the foul, Lordship. Foul, 31 of 25, page 54.
No, before that, where is the impugn order? Impugn
Impugned
order is-
order is Lordship at page 145. Annexure 3. This is the impugned order, Lord. And the operative findings are recorded by the learned. The learned trial court find a prima facie case. But on that the issue involved with the huge amount, refused to grant the ex parte injunction. Lordship, may be pleased to come to page 149. Page 149, Lordship, para 5, at the bottom. Lordship got it?
Yes,
Yes, at the bottom, para 5. I have gone through the two judgments relied upon by the petitioner, Ms. So-and-so, so-and-so, so-and-so. At this juncture, I have gone through the main suit at length, including the documents and relied upon by the plaintiff petitioner. The present suit is basically for declaration of permanent mandatory injunction as claimed and revealed from the materials on record. It seems that the plaintiff petitioner have basically stated that after return of Sri Lokesh Anand Singhal, that is one of the appellant's petitioner, Lordship, petitioner number 2 from USA to Guwahati, and when the executant is present, the conditional power of attorney given by the petitioner number 2 stands revoked automatically. It has further been highlighted that Sri Manoj Kumar Jalan, in collusion with Vivek Anand Singhal, fraudulently executed the deed on reconstitution of the Pride Realty. It is a partnership firm, Lordship, violating the mandatory conditional provision contained in clause 2 and 11 of the conditional power of attorney, and thereby deleted the petitioner number 2 name from operating the bank account of the said firm. It has further been stressed that the Manoj Kumar Jalan is still using Kotak Group and its goodwill for his money laundering activities by obtaining unauthorized capital from unknown sources, and that there were financial irregularity on behalf of Manoj Kumar Jalan, and that the bank account of the Kotak Group, which was earlier freeze, was ordered to be defreezed. misarbitration case number so and so. I have considered all the documents that have been relied upon by the petitioner. As per the document number 29, admittedly, this court of the civil judge, senior division number 1, Kamrup, had order dated 19/12/24, had passed an ex parte injunction defreezing the current account number so and so. Admittedly, the defendant number 1 and 2 still accept Manoj Kumar Jalan as the sole sole financial signatory for the signing checks and debit instruments. The gist of the present matter is welfare of the stakeholder. Without the customer, their hard-earned money. Accordingly, from the materials available on record and from a comprehensive study of the case record and furthermore considering the claims of the petitioner plaintiff, it seems that the plaintiff have a prima facie case to go for trial. A prima facie case exists when the plaintiff has a good arguable case and there is a real substantial question to be tried. As already held, the interest of the customers and their hard-earned money is of the for more interest in deciding the present prayer for injunction, and hence every detail need to be taken in case care to be taken to find out the balance of the convenience in case of the granting ad interim injunction as prayed for. As discussed above, IndusInd Bank still accepts the Manoj Kumar Jalan as the sole financial signatory for signing checks. Hence, under circumstances, any ex parte order directing any deviation from such existing process of the signing check is passed without hearing the other side, then the same may cause prejudice to the stakeholders, especially the customers of the Kotak Group at large. The balance of convenience in such situation will not be in favor of such stakeholders, and they may suffer great inconvenience in ex parte ad interim injunction is passed today as prayed for. Moreover, in case no ex parte ad interim injunction is passed as prayed for them, then in my opinion, will not cause irreparable loss to the petitioner in the present juncture of the case. Matter as claimed by the petitioners relates to economic matters, and hence before granting injunction, business realities and convenience of all the stakeholders have to be taken into consideration. The issue of fault of business transaction may arise in the present circumstances of the case. If any ex parte ad interim injunction is passed now, restraining the hope is prayed for by the present petitioner, the bare necessity of considering the convenience of all the stakeholders, including the customers, is prime in determination of the present prayer for ex parte ad interim injunction. Hence, in the circumstances of the case, balance of convenience also does not necessitate the grant of the ex parte injunction, restraining the Indus Bank to consider the written consent of all the partners of the firm and the directors of the company respectively. In my opinion, the Inns of Justice will meet if the opposite OPs are heard first before passing any order on the present situation. This part is regarding issuance of notice of lot. Now, your lordship may please to come to the prayer averments made in the plaint lordship. Nothing has been discussed regarding this because lordship through the MU dated 23rd of September 24, all dispute between the partners or directors in respect of all the entities of the Kotak Group were settled lordship. That MU your lordship will find. Before that, I would like to place the averment made in the plaint lordship that your lordship will find at page 54. This is the part. Page 54 of the Power Lordship.
Yes.
Para number, page 54, Lordship, para number 41, this is the part of the plaint. MU terms of settlement, that after multiple attempts and persuasion by the plaintiff number 2, Shri Manoj Kumar Jalan, defendant number 2, come out to the terms of the settlement and distribute assets of the Protect Group to part ways with Shri Manoj Jalan. 1, Shri Aditya Parasmika acted as the mediator to settle the dispute between the parties, and through the said mediator, Shri Lokesh Anand Singhal, plaintiff number 2, and Shri Manoj Jalan, defendant number 3, and Shri Vivek Anand Singhal, defendant number 4, came to the terms for resolution of the dispute and executed memorandum of understanding dated 23/9/24 for terms of the settlement. This MOU was a conciliation and the arbitral award to settle the dispute and distribute assets of the Protect Group. The possession and custody of the original copy of the said MOU is with Shri Vivekanand Singhal, defendant number 4, and he may be directed to produce the same if and when required. Para 42, that as per clause number 6 of the said MOU dated 23rd September 24, which provides office and other infrastructure will go to single family, that is the petitioner's appellate lordship. It can be easily seen that the Protect Group and its office and other infrastructure was to be left with the single family, that is the appellant's lordship. Therefore, clearly implying that the Manoj Kumar Jalan was to exist the Protect banner and jump ship to continue with his already running on brand Ambika Group. Ambika Group proprietary is your lordship Manoj Jalan. Right after the MOU dated was signed by Shri Lokesh Anand Singhal, Shri Manoj Kumar Jalan, both the plaintiff number 2 and his mother Shilpi Anand Singhal, number 3 to sign multiple financial balance sheets. So, lordship, my humble submission is this, lordship. Once a MOU was executed between the party to resolve the dispute, lordship, due to intervention of a mediator between the party, that is treated always as a conciliation proceeding, lordship. And this was the most vital fact, lordship, because, lordship, now the parties are to act as per the terms and conditions of the MOU, lordship. And now, your lordship, I would like to place before lordship the MOU, which were executed by the plaintiff, and this fact was suppressed by the defendant.
Where it was suppressed?
Yes, lordship. Your lordship, may be pleased to take up.
Here not. Where it was suppressed?
Lordship, an application was filed by Manoj Kumar Jalan on behalf of Pride Realty, which is a partnership firm,
In the Miss case?
in Miss Arbitration case. The application was filed under Section 9 of the Arbitration Act.
In a different case?
Different case, but the
different.
same Protect Group real entities, lordship, Pride Realty, in which present appellants petitioner, they are also the partners, lordship. And this expert injunction was obtained, restraining the present petitioner's appellant lordship from managing the day-to-day affairs of the firm, lordship. In a partnership business, lordship, as per the provisions of the Partnership Act and as per the terms and conditions of the partnership deed, a partner cannot be restrained, lordship, from participating in the business of the affairs, lordship. And against which, lordship, I appear, and this order was obtained. This, if your lordship, when in the petition filed under Section 9 of the Arbitration Act, if this MOU could have been, averment could have been made and the document would have been filed, the petition under Section 9 Arbitration Act will not be maintainable at all. Because, lordship, there are series of Supreme Court decisions, our High Court decisions are these, that once a dispute was settled between the parties through any process, it will be treated as a conciliation or.
But that is not before this court now.
No, lordship. My humble submission in this, lordship, that when the plaintiff of the present suit, lordship, the averments are clearly mentioned regarding the MOU, lordship. But while giving the findings, the learned trial court committed a perversity, lordship. in not discussing anything regarding the MU. I have placed already the improvement order relevant portion, operative portion before your lordship. There is no whisper regarding the MU dated. This is the vital question, lordship. That's why I filed this appeal. Otherwise, I would have filed matter could have been heard there after filing objection. And what the lordship defendant did in this present suit, lordship, before the learned trial court, they filed an application under section 8, lordship, of the Arbitration Act for referring the matter to the arbitrator when the matter has been already arbitrated on 23rd September 24, lordship. There cannot be any question of second arbitration, lordship. And this gross perversity has been committed by the learned trial court. Now your lordship will be pleased to come to page 146 of the IA, which is the MU, lordship. The suppression of facts of a material fact is a very serious thing here, lordship. The fraud was committed not only upon the court, but upon the appellant petitioners and firms.
Page 146 of IA.
IA, lordship, annexure 20. उस पोस्ट के बोलने के अनुसार हम कर बोले चुप shut up.
Yes.
Lordship, this is the MU which was executed on 23rd 9/24 between the parties, lordship. And here, your lordship, it is clearly mentioned that
Clause 4.
lordship, all the properties of the Protect Group has been divided between the single family and the Jalan family, lordship, which was never challenged by the respondents, lordship. If a party is aggrieved due to execution of the settlement agreement, only remedy is to file a civil suit for the cancellation of the MU. The court cannot decide the legality or validity of the MU, lordship. Only civil court will decide. Other court under section 9 of the arbitration, it cannot be decided, lordship. Any new arbitrator second time cannot be appointed, lordship. And here, lordship, you will see that here the Pride Realty, in which case, lordship, the Manoj Jalan has filed an application under section 9 of the Arbitration Act and got the ex parte injunction order. That has been assigned to Manoj Kumar Jalan. Your lordship will clearly find here. I may be permitted to place page 146. Today, 23rd. Clause number 3, lordship. Clause number 3. Protect Pride, a partnership firm, will be 100% given to Manoj Jalan and family. Like this was, lordship, all the properties of the builder company Protect Group were divided between the single family and Manoj family. Manoj family.
Yes.
Now, your lordship will be pleased to peruse the petition filed under section 9 of the Arbitration Act by the defendants, lordship.
Page number.
Yes, page. Page, lordship. The respondents have filed their objection, lordship, in the IA. And there your lordship will find the petition filed under section 9 of the page 345. Your lordship will be pleased to take up the affidavit in opposition filed by the defendant.
Yes.
Lordship got it?
Yes.
Now, lordship, this is a petition by Pride Realty, one of the partnership firms, which was filed by Shri Manoj Kumar Jalan and others, lordship, against the present appellant, lordship, appellant. under section 9 of the Arbitration and Conciliation Act. Your Lordship, be pleased to note that this petition under section 9 of the Arbitration Act was filed by the respondent on 18/12/24. 18/12/24, Lordship. Which can be verified from the affidavit date, page 369. Page 369, Lordship. Page 369, Lordship, at the bottom portion. This affidavit was sold 18/12/24. And in this petition, Lordship, there is no whisper regarding the MU, dated 23rd of September 24. Because if the matter of MU would have been averred, or the averment would have been made in the petition filed under section 9 of the Arbitration Act, the Honorable Trial Court has never granted any ex parte injunction. So this is a fraud, Lordship, committed by the respondent, not only upon the Honorable Court, upon the appellants also. Appellant, there is no whisper. I have gone through the entire petition because there is nothing regarding the MU dated 23rd September 24. Now,
Yes.
Now I would like to place some of the judgments, Lordship, regarding the submission I have submitted before you, made before your Lordship. Yes, sir. Thank you. I am supplying the Xerox copy.
What has happened to the arbitration case?
Arbitration, no, it is going on because Lordship, the matter was transferred from the Court of the London. It was filed originally in the Court of the London Civil Judge Senior Division number 1. But thereafter it was transferred to the Civil Judge Senior Division number 2, Lordship. And repeatedly, thereafter the presiding officer was transferred. For a long period, there was no presiding officer. Now the new incumbent has joined 10 days back. Where is the date?
Okay, yes. What rulings you want
Tomorrow,
to?
tomorrow the matter is fixed, Lordship, arbitration matter. Arbitration. Now, I'd like to place before your Lordship your Lordship, please to come. I have supplied this set of judgment, Lordship, page 11. This is the Apex Court judgment, Lordship. Citation is, Lordship, 2000 within bracket 6 SCC 179. Parties are, Lordship, Harish Dayaram Thakur versus State of Maharashtra. Relevant paras are, Lordship, 90.
What it says.
Continuous page 17 of the and para 19, Lordship. Page 17, para 19.
Yes. What it says?
It says that para 19, from the statutory provisions noted above, the petition is manifest that the conciliation is a conciliator is a person who is to assist the parties to settle the dispute between them amicably. For this purpose, the conciliator is vested with wide power to decide the procedure to be followed by him, untrammeled by the procedure laws like the CPC procedure or the Indian Evidence Act. When the parties are able to resolve the dispute between them by mutual agreement, and it appears to the conciliator that there exists an element of settlement which may be acceptable to the party. He is to proceed in and the party conciliator that there exists an element of settlement which may be acceptable to the party. He is to proceed in accordance with the procedure laid down in section 73, that is 73 of the arbitration. Formulate the terms of a settlement and make it over to the parties for their observation, and ultimately steps to be taken by the conciliator to draw up a settlement in the light of the observation made by the party to the terms formulated by him. The settlement takes shape only when the parties draw up to the settlement agreement or request the conciliator to prepare the same and affix their signatures to it. Under subsection 3 of section 73 of the settlement agreement signed by the party is final and binding on the parties and persons claiming under them. If follows therefore that a successful conciliation proceeding comes to an end orally, then the settlement agreement signed by the parties comes into existence. It is such an agreement which has the status and effect of the legal sanctity of an arbitral award under section 74. This judgment I have placed before the learned trial court lordship. Personally, I had argued the case and my learned friend has represented the respondent lordship. But no whisper in the impugned judgment lordship regarding this form that the MU dated 23rd September 24 is nothing with a conciliatory award, which can be challenged only by filing a civil suit for the cancellation of the MU on the ground of fraud or any other law laws. Next judgment is lordship. Page 19. Page 19. Page 19, Your Honor, parties are Jagat Nation and others versus Vaikuntha Ranjan and others, reported in Lordship 2019.
7 MLG.
7 MLJ 323. This is marvelous judgment on conciliation proceeding Lordship. Para 14, 15, 19, and 23. I have written about the first page Lordship relevant paras. Lordship, page 24, para 40.
Yes,
Lordship got it?
yes. Yes.
Para 40. If the partition deed document is accepted as a result of the conciliation proceeding and accepted as an award, the same can be assailed only in a proceeding initiated under section 34 of the Arbitration and Conciliation Act. If it is not accepted as a conciliation award, the document would retain its is alleged that character as a partition deed. When admittedly the parties have consented to the document, and if it is alleged that it was obtained by coercion and under influence, the same has to be proved in the manner known in law by the petitioner. In the absence of any proof to substantiate such contention, it is not open to the petitioner to unilaterally cancel or revoke the same. If the document is not conciliation agreement, then it would be family arrangement partition. The intention of the partition deed was only to bring about harmony in the family, resolving all the disputes and differentiate that existed by that point of time. The person who reconciled the dispute is the stepbrother of the first petitioner and the first respondent. He had adopted the practice in their community as a trade family, and if one brother divided the property, the other brother had the option of selecting the property. Section 61 of the 61 within bracket 1 of the Arbitration and Conciliation Act says that the same as otherwise provided by any law for the timing in force, and unless the parties have otherwise agreed, the said part shall be a conciliation of the dispute arising out of the legal relationship, whether contractual or not, and to all proceeding relating thereto. In the present case, the parties having otherwise agreed as per their customs and practice in their community, it is not open to the petitioner to say that section 61 was not complied with. The above act of the parties clearly goes to show that they have arrived at the consensus by waiving the procedure contemplated under section 61 within bracket 1 of the Arbitration and Conciliation Act and the subsequent provisions relating to section 62 to 74 of the Arbitration Act. Para 19 laws. Sorry, para 15, sorry. This para is based upon a Supreme Court judgment law. Para 15. Reliance has placed on the judgment of the Honorable Apex Court in so reported in 2000 within bracket 6 SCC 17, where it was held that from the statutory provision noted above, the petitioner is manifest. The position is manifest that a conciliator is a person who is to assist the party to settle the dispute between them amicably. For this purpose, the conciliator is vested with wide power to decide the procedure to be followed by him, untrammeled by the procedure law like the CPC or the Indian Evidence Act. When the parties are able to resolve the dispute between them by mutual agreement, it appears to the conciliator that there exists an element of the settlement which may be acceptable to the party. He is to proceed in accordance with the procedure laid down in section 71. Formulate the terms of the settlement and make it over to the parties for their observation, and the ultimate step to be taken by the conciliator is to draw up a settlement in the light of the observation made by the parties to the terms formulated by him. The settlement takes shape only when the parties draw up the settlement agreement or request the conciliator to prepare the same and affix their signature to. Under subsection 5 of section 73, the settlement agreement signed by the party is final and binding on the parties and persons claiming under them. It follows, therefore, that a successful conciliation proceeding comes to an end, and only when the settlement agreement signed by the parties exists such an agreement which has the status of effect of legal sanctity of an arbitral award under section 74. Then Lordship may come to para 23 and 24. Page Lordship 28, para 23.
Yes.
The question that arises is whether the said partition is an award, or if so, whether it requires registration. After fixing required stamp duty, it is deemed to be a partition deed, which came to be executed by misrepresentation or undue influence. Then the remedy for the petitioner is to go before the civil court. The Kathalkadi partition is the outcome of all the issues being settled in the family. Though the council could not explain the meaning of Kathahadi, it only indicates that the that the partition is as per the custom prevalent in the trading families of the area community. Having admitted the execution, but pleaded undue influence and misrepresentation, the document is only viable, which has to be set aside in the manner known to before the civil court after trial. If it is an outcome of the conciliation and that is an award, whether it requires registration or a stamp duty payable can be agitated in a petition filed under section 34 of the arbitration, and therefore by no stress of imagination the petitioners can ask for reference to arbitral tribunal when they are seeking to set aside the document admittedly signed by both the parties, unless and until the document is set aside in the manner not to law, they cannot attack the validity or otherwise of the same in the present proceeding. So Lordship, once the MU was executed between the parties on 23rd of September 24, and while filing the petition under section 9 of the Arbitration Act, that fact was suppressed by the respondent Lordship. And till date, the respondents have not filed any suit, Lordship, for the cancellation of the MU dated 23rd of September 24, Lord. So that is binding upon both the parties, Lordship. So this vital aspect, all these facts were placed before the learned trial court, but there is no whisper in the informed judgment, which has caused the perversity of to the great extent, Lordship. Because, Lordship, if matter cannot be arbitrated twice, Lordship, if a conciliation proceeding or the award has reached its final stage, only remedy is to file the appeal or file a civil suit, Lordship. Nothing has been done till today by the respondent defendants, Lordship. Now, Your Lordship, the next citation, page 29. Page 29. Relevant paras are, Lordship, parties are Sanjit Singh Salwan versus Sardar
Yes.
Their Lordship, the citation is of Lordship 2025, latest judgment, 2025 Supreme Court, Lordship, page 1209. Parties are Lordship Sanjit Singh Salwan versus Sardar Indrajit Singh. Relevant paras are Lordship, para 15, 17, 18, 19, and 20. Para 15.
To emphasize which point you are showing this judgment.
Point on the doctrine of estoppel. Once a party has executed or arrived at a settlement lordship due to MU or a lordship, the parties named therein lordship cannot their actions will be hit by the doctrine of estoppel, and that is the law laid down by the apex court. Lordship, may be pleased to come to page 35. Page 35, Lordship. Page 35, para 15, Lordship. Lordship, got it?
Yes.
Yes, page 35, para 15. Para 15, Lordship. This is also based on that Supreme Court judgment. This position is fortified by the decision of this court in Mumbai International Airport Private Limited. It was held therein as under. Is an action of law, is a game of chess. Can a litigant change and choose its style to suit its convenience and prolong a civil litigation on such prevaricated plea
No,
the-
no, but this argument you should have made before the court where the arbitration 205 is pending. This is against.
No, whatever I am arguing, I am placing before your lordship. I had argued all those points. I have placed all the documents.
Before
I
the
have placed-
arbitration matter,
No, before, in the suit.
which suit?
The suit which has, present suit lordship. And also in the petition filed under section 9 lordship, we have filed our objection annexing all those.
No, that matter is not before us. Section 9 matter is not
No.
before us.
Lord. But it is related because the, in the improved order, the learned trial court had given some findings, lordship, regarding the petition filed under section 9 of the arbitration.
No, here you have impugned only the rejection of ad interim ex parte injunction.
That is correct.
That
I
is
have
the only
challenged-
subject
I
matter.
have challenged. No, my submission is lordship, when the MU was executed on 20.
No, that I have understood that
That I.
an MOU
Now,
was,
now your lordship in the present suit, the respondent have filed an application under section 8 of the Arbitration Act for referring the matter to the lordship.
what order has been passed on that?
Till date lordship, nothing.
So
of-
that is also before the trial court.
That is before.
That
the
is
trial.
before the trial court. The
Right.
matter before us is whether the court in refusing ad interim ex parte injunction to you on the first date and by issuing notice
Hmm.
heard whether any wrong has been committed. That is the limited
Wrong has
question.
been committed lordship when the
Wha-
plain there
one
are
query.
specific.
While deciding, while passing the impugn order, whether the trial court decided the issue on merits, it did not decide the issues on merit.
I already have submitted before lordship when there are very categorical averments in the plain regarding the MU dated 23rd of September 24 lordship. And clearly stated in the plain, I have already placed that the matter dispute between the parties was settled amicably through conciliation, lordship. That aspect has not been touched by, there is nothing noticing,
Yes.
whisper in the findings given by the learned trial court. So that is the perversity of writ large on the face of the record, lordship. Such a vital point has been not touched, lordship. No findings have been given regarding the impact of the, what will be the impact of the conciliation proceeding dated 23rd September 24, and whether the petition filed under section 8 of the Conciliation Act will be maintainable or not, lordship. So perversity is writ large on the face of record, lordship. Apart from that, lordship, the learned trial court, while clearly I have cited all these judgments which I have placed till now before your lordship, I had placed those judgments also. That is also xeroscopy as I have supplied, but nothing is. There is no finding regarding the MU, lordship, dated 23rd of September 24. If there would have been some findings, the matter would have been different. That the learned trial court has considered regarding the MU, given its finding, and found that the balance of convenience is not in favor of the petitioner's plaintiff, lordship. There is nothing which has caused lordship. If in the present case, the petitioner who are the partner.
No. What I have understood till now, if there is something remaining, you may submit. That trial court refused to grant you ad interim ex parte injunction by holding that though there is a prima facie case, but as matter involved the interest of other stakeholders, it is trial court found it fit to hear the other side before deciding that is the only.
That finding is also, this is my humble submission before Lord. That finding is also a perverse one, because that was not a suit in a representative capacity. What will happen to the stakeholders, that issue was not before the learned trial court. Dispute is between the plaintiff and the defendant. the finding given by the learned trial court that the other intended purchasers or the shareholders of the stakeholders will also suffer irreparable loss and injury if the ex parte injunction is given. That is not a pleaded case, Lordship. In the plaint, it is clearly mentioned that dispute is between the plaintiff and the defendant, where from the other stakeholders have come. So that is also a perverse finding.
Okay.
Because that was not a suit in a representative capacity. The other stakeholders, there was no prayer, Lordship, for for saving the interest of the stakeholders, Lordship. And till date, Lordship, this respondent Manoj Jalan, Lordship, has siphoned of more than 35 crores rupees from the fund of the plaintiff petitioners, Lordship, till date. And because he is running, he has opened his own group, Ambika Group. That averment is also there in the plaint, Lordship. So if my Lordship, what is my grievance or plea, Lordship? Simply I want that all other directors, partners may authorize Sri Manoj Kumar Jalan to sign the checks and on behalf of the companies or firms. I have no objection at all. I don't want that the account should be freezed, Lordship. But I want that my signature should be also taken over the checks, Lordship. With consent of all the parties, the Manoj Kumar Jalan can be authorized to manage the affairs of the matter.
What relief you are seeking in the title suit?
Title suit, Lordship.
In the main suit, what relief you are seeking?
Lordship, please to peruse my prayer. Prayer. Lordship, may you please to take a memo appeal, Lordship, where I have
Page number
page 41, 81, sorry,
51.
81. Memo appeal file.
Yes.
Page 81, prayer number 1. Declaration that the plaintiffs in different capacity are the partners of the plaintiff number so-and-so, partnership firms and plaintiff number 10, 11 LLPs and director of the defendant number 5, 6, 7, 8, compliance with all, which are all entities of the Protect Group along with other sister company subsidiaries as listed in the document number, and the plaintiffs are entitled to sign the check or any other negotiable instrument as per the terms and conditions of the partnership deed agreement with consent of the rest of the partner director, and that Sri Manoj Kumar Jalan and dependent number cannot operate the bank accounts of the Protect Group partnership singly handling. So, Lordship, that is my prayer. That I have no objection at all, Lordship, if all other partners, the director authorize the dependent number 3, Lordship, to operate the bank account, or to draw the money. But the signature of the present petitioner, Lordship, should be there, Lordship. Otherwise, as per the partnership, Lordship is fully aware. Partnership Act provides that all the partners will be entitled to manage the affairs of the partnership firm, Lordship. Partnership firm. And I would like to place the and Lordship, in the petition filed under section 9 of the Arbitration Act, when the ex parte injunction order was granted in favor of the respondent, Lordship, there is no order that only Manoj Kumar Jalan, defendant number 3, will operate the bank. There is no such order. But bank, Lordship, defendant number 1 and 2, they are allowing only Manoj Kumar Jalan, and he is withdrawing huge money. Which is, as such, there is a collusion between the bank official and Manoj Kumar Jalan. Manoj Kumar Jalan. Now, Lordship, like to place the other judgments of the apex court. Lordship may be pleased to come page 41 of the judgment set.
Yes,
Page 41, citation is Lordship 2019, 6 SCC 409. Parties are Tulsi Dhara and others versus Narappa and others. Paras are Lordship, I have written over the first page. 9.3, 9.4 and 9.5.
estoppel. Okay,
Nine point. 41. Page 11 portion, Lordship, page 56. Para 9.3. Page 56, 56.
yes,
Now, so far, the finding recorded by the High Court that as the partition did so and so was unregistered through which required registration under the provisions of the Registration Act, and therefore the same is not admissible evidence is concerned. It is required to be noted that as such the exhibit D4 can be said to be a Palupati as has been described as Palupati. Palupati means list of the properties mentioned at the most. It can be said to be a family arrangement. Therefore, in the factual circumstances of the case, the same was not required to be registered. Now, let's say may have to come to para next page 57. Para 9.5. It is required to be noted that the deed dated so and so, under which the suit property has gone devolved in favor of the Krishna Pada, was reduced in writing before the Panchayat and Panch, and the same was signed by the village people, Panchayat people, and all the members of the family, including even the plaintiff. Though the plaintiff disputed that the partition was not reduced in writing in the form of the document Exhibit D4, on considering the entire evidence on record and even the deposition of the plaintiff cross-examination, he has especially admitted that the oral partition had taken place in the year 1971. He also admitted that he has not got the share with the document that is written Exhibit D4. Execution of the document partition deeds Palupata dated so and so has been established and proved by examining different witnesses. The High Court has refused to look into the said document and or consider a document dated so and so Exhibit 4 solely on the ground that it requires a registration and therefore it is unregistered. The same cannot be looked into, however, as observed by this court in the case of Kale Supra, that such a family settlement, though not registered, would operate as a complete estoppel against the party to such family settlement. In the aforesaid decision, this court considered its earlier decision in a case of so and so and others reported in 73 to SC 3112, in which it was observed as under equitable principles such as estoppel, election, family settlement are not mere technical rules of evidence. They have an important purpose to serve in the administration of the justice. The ultimate aim of the law is to secure justice. In the recent times, in order to render justice between the parties, courts have liberally relying on those principles. We would hesitate to narrow down their scope. As observed by the court in so and so, that if a person having full knowledge of his right as a possible reversal entered into a transaction which settles his claim as well as the claim of the opponent at the relevant time, he cannot be permitted to go back on that agreement when reversion actually falls open. Para 9.5, as held by this court in case of so and so, without registration, a written document of family settlement, family arrangement can be used as corroborative evidence as explaining the arrangement made there under and conduct of the parties in the party in the present case, as observed herein above. Even the plaintiff has also categorically admitted that the oral partition has taken place on this and that, and he obtained that 3 to 4 panchayat people who were also present. However, according to him, the same was not reduced into writing. Therefore, even accepting the case of plaintiff that there was
No,
an
these are
oral.
not relevant.
Okay,
These are not
okay.
relevant.
Next page. Next judgment is page 50. It is also on the estoppel. I'm allowed to escape. Then
Your submission is that once there is a family arrangement, the parties to family arrangement are stopped from taking a contrary stand.
contrary.
That is your
Yes.
submission.
There are many series of judgments I have given lordship.
On the same point. One judgment is enough.
One judgment, it is very relevant, important lordship. Page
Which one?
83.
Page?
83. Kapka citation? Is it?
Yes. Calcutta. I think.
This judgment is lordship, 2008 AIR Calcutta 10. This is a very remarkable judgment lordship, regarding partnership firm. Relevant paras only 12. Para 12, page 85.
Yes.
Regarding joint account lordship. In case of a joint account opened by more than one person, one of the joint account holder can definitely ask the bank even not to operate the account any further. And in such a case, the bank cannot ignore the instruction of the agreed account holder simply because he or she is merely one of the joint account holder, and that all the joint account holder have not given such instructions similarly. If one of the joint account holders decide to change the mode of operation, operating the account, which was initially agreed by the parties, the bank should not continue with the account based on the instruction initially given to it, so long as the dispute is not settled by the parties. So, your lordship, the petitioner, appellant lordship, have submitted series of application with the bank lordship that I am also one of the partner and I am authorized to sign the checks or other instrument under the NI Act lordship, but the bank is recognizing only the defendant number 3, Sri Manoj Kumar Jalan, to withdraw the money or to do all other things lordship. And in the all the partnership, I have annexed along with my IO lordship, all the partnership deed, which authorizes all the partners lordship to operate the bank account. And in case lordship, other partners authorize one of the partner, then he can do. But in the present case lordship, the bank is even not recognizing me as one of the partners of the party. And somewhere in other letters, the bank is recognizing the petitioner as the partner. And so in some letters, lordship, the bank is saying, no, you are not recognized. Next, lordship. Our own High Court judgment is there, lordship, page 87. Lordship, this page 87, this is our High Court, on our High Court division bench judgment, lordship. What happened, lordship, when the dispute arose between the parties, lordship, the bank, lordship, issued the letters to the petitioner as well as the respondent.
You have
lordship.
made bank as a party in the suit.
Yes, bank is the respondent number 1 and 2. In the suit, the defendant number 1 and 2.
Okay.
I have annexed the copy of the plea. Bank, my learned friend is representing the bank, Mr. Gogoi.
Okay, yes, please.
So,
please.
lordship, the defendant and respondent lordship did not revalidate the KYC, which is required to be done, lordship. Series of letters were issued by the bank for revalidate the KYC, lordship, but it was not done by the defendant respondent because he was withdrawing the money from the accounts, lordship, huge money. And the same matter has been set at rest by our own High Court Division Bench judgment, reported in lordship 2019 September, Guwahati 116. Relevant portion is para 5, Lord.
Yes,
Para 5, page 89.
Mm.
89.
yes.
Para 5. From the
Read
bottom,
the
Lord.
highlighted portion only.
Yes, highlighted portion, though that with the positions, the respondent bank have also indicated in the affidavit filed in this appeal that the appellant has not complied with the KIC norm. Certainly, the appellant is required to comply with the same, as otherwise the regulation of the RBI would not extend satisfied. It is further clarified that the appellant shall contact the respondent bank and furnish the details so as to comply with the KYC norms, lordship. So this is the till date, lordship, the KYC norms have not been fulfilled according to the law, your lordship, as per the lordship, the bank book 10. Lordship, all over India, this book is followed by the bankers. This is bankers manual by Tennant, lordship. Copy. Relevant portion I have given. This laid down that if the KIC is not furnished, account should be stopped immediately. It should be kept under suspension. There cannot be any transaction. Lordship, I have highlighted the relevant portion. And if your lordship, I am having the original book also. Lordship, para 146. Second page of this banker's manual, lordship. The 146, operation of the funds bank account. As the drawing of the checking necessary in almost all kinds of business, the bank justified in honoring checks drawn in the firm's name and signed by the partner, unless it has received a special instruction to the contrary or knows that the partner who has drawn the check in the firm's name is not authorized to do so. In this case, a notice from one or more of the partners to the bank cancelling the authority of anyone or of the other partners would be sufficient notice to the bankers to act upon. Similarly, one partner has an implied authority to stop the payment of a check drawn on the firm account by another, and the banker is bound to comply with the instruction issued by the partner. Next, lordship, 147. One partner may stop further operation when joint bank account was opened by the three individuals carrying on the business. A specific instruction was given to the bank that the joint account of the partnership firm should be operated on the signature of any of the two of the partners. Such bank to stop further transaction in such a case unless all the 3, persons appear and account conjointly, the bank should immediately stop operation of the account as parties to resolve their dispute amongst themselves. Then may come to third page, Lordship. 81, para 81. At the bottom, Lordship.
Yes,
Mode of operating bank account. As one of the partner has the authority to revoke the mandate of the conducting the bank account, they may, the bank account which may have been given by any other partner. That means any partner can countermand the payment of a check issued to another part, issued by another partner on behalf of the foreigner. In spite of that, Lordship, the petitioner appellant have given the series of letters to the bank, Lordship, that the check issued by Manoj Jalan should not be encased or should not be honored, as because there is a dispute between the parties and KYC revalidation has not been done by the defendants, respondent, Lordship. But still, till date, Lordship, the bank is paying Manoj Kumar Jalan, that is respondent number 3, is drawing huge money from the firm's account. So
okay.
this, and I am having the original book. If your honor allow me, I can submit this book
Not-
regarding the transaction
No,
of the
not necessary.
bank account. Then Lordship. Regarding Lordship, there is RBI. Lordship, I have also submitted RBI guidelines regarding KYC, Lordship, which is the master direction for the validation of the KYC. Your Lordship, may please to come to the last page. Last page on the
Yes,
at the bottom, your Lordship will find para 39, Lordship. Para 39.
yes,
In case of existing customers, RE shall, RE means regulated entity shall obtain the permanent account number or equivalent.
regulated entity is a bank.
Yes, sir. Thereof of Form 60 by such date as may be notified by the central government, failing which the RE shall temporarily cease operation in the account till time the permanent account number equivalent to e-document thereof form number 60 is submitted by the customer, provided that before temporarily ceasing operation for an account, the RE shall give the customer an accessible notice and a reasonable opportunity to her. Further, RE shall include in its internal policy appropriate relaxations for continued operation of the account or customers who are unable to provide permanent account number or equivalent e-document thereof or form number 60 owing to injury, illness or infirmity on account of old age or otherwise, and such like causes such account shall however be subjected to enhanced monitoring, provided further that if a customer having an existing account based relationship with a RE giving in writing to the RE that he does not want to submit his permanent account number or equivalent e-document thereof or form 60, RE shall close the account and all obligation due in relation to account shall be appropriately settled there, establishing the identity of customer by obtaining the identification document as applicable to the customer explanation. For the purpose of paragraph, temporary ceasing of operation in relation to account shall mean the temporary suspension of all transaction or activities in relation to that account by the RE. Till such time, the customer complies with the provisions of this paragraph in case of asset accounts such as loan accounts for the purpose of ceasing the operation in the account, only credit shall be allowed. So, Lordship, after Lordship, The MU was executed, Lordship, be pleased to consider on 23rd September 24. Almost one year has gone. Now, Your Honor, thereafter, Lordship, when the bank gave the notices to both the parties, Lordship, for the revalidation of the KYC, Lordship, and till date it has not been done. And surprisingly enough, the bank is not suspending the operation of the account. Not though, Lordship, as per the law regulations, Lordship, led by the RBI, as per this law, Lordship, I have placed before your Lordship, if the KYC is not revalidated, Lordship, the account ought to be kept under suspension and no one can withdraw the money.
Okay.
And so after 11 months I gone, no KYC has been revalidated. Still, huge money is withdrawn regularly by the respondent number 3, that is Manoj Kumar Jalan. Though he has, actually as per the MU, he has no right to withdraw any money for the protect group, which was as per the MU allotted to the single family lot. Because already MU has been settled. His 100% property of Pride Realty Lordship has been given to Manoj Jalan along with other properties also, Lordship, as enumerated in the MU dated 23rd of September 24. But he has been enjoying the shares which were allotted to him as per the MU, and he is also enjoying of the property which was allotted to the petitioner appellant's Lordship. This is the Lordship and committing the fraud, suppressing the material facts regarding the MU, Lordship. So regarding now.
Now please conclude.
No, it will take some time.
You have
Your
taken sufficient time.
No, but I am not.
Which point you want to
There are
emphasize?
other points, Lord.
What points?
If today it is not possible, it may be fixed on Tuesday.
No. We'll dispose it of
There
today.
are most vital points, Lord.
You cannot continue forever.
Lordship.
How much time will you take? How much more time will you take?
Half an hour, I think.
Okay, take that half an hour. But after half an hour, I will not allow you to submit further.
I'll leave to you, Lordship. Now the next judgment is, Lordship, page 91 regarding KYC.
KYC you have submitted.
Already
That
one
unless
judgment is-
KYC.
KIC I have submitted our Honor High Court judgment. Lord. Then para 4, 5, 6. Page Lordship 90. हमको तुम करने दो, देखो,
93 to emphasize which point?
to exercise your Lordship. This is regarding your Honor, regarding the prima facie injunction, Lordship.
Injunction, but
prima
in this
facie
case,
case, balance of
injunction is
convenience.
ex parte ad interim injunction.
Lordship.
Dalpat Kumar speaks about injunction generally.
Yes. This is a famous judgment of Lordship is aware.
But the case before us is of an ex parte ad interim injunction. A refusal to grant ex
No,
parte.
no, that is, this is a very short judgment, Lordship. I may be allowed to place. The cardinal principle laid down. by the
Yes, please.
Your Lordship may be pleased to come to
4, 5, 6.
page 94, Lordship. From the bottom, I have the highlighted portion only. It is certain law that the grant of injunction is a discretionary relief. The exercise thereof is subjected to the court satisfying that there is a serious disputed question to be tried in the suit, and that and at the facts before the court, there is probability of his being entitled to the relief asked for by the plaintiff defendant. Number 2, the court interference is necessary to protect the party from the species of the injury. In other words, irreparable injury or damage would ensure before the legal right would be established at trial. And three, that the comparative hardship or mischief or inconvenience which is likely to occur from withholding the injunction will be greater, then that would be likely to arise from granting it. Then Lordship, next page, Lordship, the highlighted portion only. The court further has to satisfy the non-interference by the court would result in irreparable injury to the party seeking relief, and that there is no other remedy available on the party except even to grant injunction, and he needs protection from the consequences of the apprehended injury or dispossession. Irreparable injury, however, does not mean that there must be no physical possibility of repairing the injury, but means only that the injury must be a material one, namely on that one that cannot be adequately compensated by way of damage. The third condition is also that the balance of convenience must be in favor of the granting injunction. The court, while granting or refusing to grant injunction, should exercise sound judicial discretion to found the amount of substantial mischief or injury which is likely to be caused to the parties if the injunction is refused, and compare it with that is likely to cause to the cause to the other side of the, if the injunction is granted. Now, your lordship, the last highlighted portion. But what's of worth and elasticity to mean median situation presented by means ingenuity in given facts and circumstances, but always help with sound exercise of judicial discretion to meet the ends of justice, lordship. And lordship, again, I am coming to the impugned order, lordship. Lordship, in the plaint, lordship, we have given the what type of injury we are going to suffer if the injunction is not granted, lordship. Because, lordship, this protect group is the one of the largest builder of the any region, lordship. There are projects, your lordship, which are having the land of say 10 bighas, 15 bighas, 20 bighas, lordship. Thousands of flats are coming out. And if the amount is swindled down or misappropriated, lordship, from by the respondent, lordship, then again, because as per the MEU, the protect group properties which has come to the petitioner's appellant, lordship, the intended purchasers will file series of cases against the petitioner appellant's, lordship, for the specific performance of the contract, by saying that as per the MEU, the property has come to you and you are responsible to hand over the flat. If the all money has been siphoned by the deponents, your lordship, to his other group, Ambika group, lordship, then that will cause the irreparable loss and injury. And the balance of convenience was always in favor of the petitioner appellant, lordship, but this vital aspect was not considered. Lordship, it is generally considered or says that in case of a transaction of money, it can be quantified. So that will not be irreparable loss, but not that, lordship. Other thing is the court, my humble submission, the court is to consider that what legal injury will be caused if the injunction is not granted. Legal injury, lordship, is this, that if the injunction is not granted, or in the meantime, almost entire fund will be siphoned off by the respondent defendant, and it is the appellant petitioner who will face the music, lordship, by contesting the series of thousands of cases which will be filed by the intended purchasers who had executed various agreements for the purchase of the flats, lordship. Because the properties, as per the MEU, lordship, the properties which has come to the share of the appellant petitioner, for that only the appellant petitioner will be responsible, not the respondent defendants, your lordship. And this vital aspect was not that. So that is also a perversity, lordship, writ large on the face of the record, which requires interference by your lordship, lordship. Then, lordship, we come to page 97. 97, this is our on High Court judgment, Lordship. Para 12, 13, 16. Reported in Lordship 1982 AIR Guwahati 16. Your Lordship, may please to come to page 100, last para, highlighted portion.
No, on injunction, no further judgment is required. You have
Yes,
cited Dalpat Kumar.
then I am skipping.
Otherwise, if you read all the judgments, my entire remaining days of roster will be consumed.
Lordship, may please to peruse the further fraudulent action, suppression of fact on the part of the defendant.
No,
Lord-
that is also not relevant here. Because suppression of fact is in the arbitration
No, no,
case,
as
section
it is not
9.
the case of suppression, Lordship. While submitting the KIC by the respondent, Lordship, they, in collusion with the bank, Lordship, the forged documents were produced, which is just, Lordship, maybe please to take up the additional affidavit number 3, only 1 page, 2 page documents, Lordship. They filed on Lordship on 28th of October.
Page number,
Page number, Lordship. 4 continuing page 451, annexure K.
four five one in
Yes, 451.
the CR.
When the bank issued letter to, in the additional affidavit number 3, Lord. File on 28
Yes,
of this,
451.
yes, 451.
This is a letter to branch manager.
To branch manager, Lordship, this was by the respondent, Lordship, by the respondent. Your
Yes.
Lordship, may please to note down on the right side top date, 15/1/25.
Yes,
Here, Lordship, 1, 2, 3, 4, 5 persons, that is the respondents have signed, Lordship. And regarding, next page, Lordship.
what is this?
This is the regarding your Lordship resolution. Resolve that
Authorizing the
mode of
authorizing
operation of
Manoj,
the bank single,
authorizing Manoj Kumar Jalan.
Jalan. Here, Lordship, 5 persons of the opposite parties respondents have signed, authorizing Manoj Kumar Jalan. And next page, Lordship, this is dated 15th of January 25. Before that, next page, Lordship, page 452. This date is also 15/1/25. Here, your Lordship will see that 5 persons have signed, 5. Next, your Lordship, the third document, 453, page 453, dated 15 January 20. So all these 3 letters, your Lordship, in 2 letters, 5% respondents have signed, and in surprisingly enough, Lordship, may be pleased to come to page.
No, what you want to emphasize by showing this?
And emphasize that, just your Lordship, then it will be matter to be clear. Please come, Lordship, may please to come to page 462. Page 62, these all letters, your Lordship, given by the Protect Group, different companies and partnership firm. Your Lordship will find the signatures of the respondent, 5 numbers or more, and but all dated 15th of January 25. But at page 462, your Lordship will see only 3 persons have signed. And other respondent defendants whose signatures are appearing on the previous letters, Lordship, in respect of the same authorization given to Manoj Kumar Jalan, only 3 persons. Then petitioner inquired from the bank manager, made, and she's a lady, Rashmi. She applied, no, the bank respondents have requested me to allow them to sign on the subsequent letters. So I allowed them to sign. Lordship, on same day, 15 January, 3 persons have only authorized. And on the, from the pages, Lordship, from the pages 451 to page 461, Lordship, all your Lordship will find the different persons have signed. Lordship, the from pages 451 to 458, your Lordship will see that some were bearing the signature of 4%, some were 5%, some were 6%, like that, Lord.
So
On this-
what you want to emphasize?
I want to say, Lordship, when the authorization has been given, Lordship, then there should be the signatures of all the partners or the directors, Lordship. So documents were tempered, Lordship, and the no board resolution was called, Lordship. When in case of companies, Lordship, we were fully aware that board meeting is to be held, Lordship. All the stakeholder or director or shareholder should be given notice for the meeting, Lordship. That was not done. Simply they have submitted a letter, Lordship, and this page 462 clearly shows that initially it was only 3 persons who has authorized Manoj Kumar Jalan, even the petitioner. Even the petitioner was not allowed to sign. And this has been then Lordship, the Lordship may be of the same additional affidavit, Lordship may be pleased to come to page 464. Regarding the fraudulent action, the petitioner appellant has given a notice to the bank through its advocate, Lordship, mentioning the name of all the entities of the Protect Group, Lordship. And
How many partners are there in this partnership firm?
in different entities, different persons, Lordship, but all the Lordship entities we have stated in the plaint also. Plaint and
Okay, okay.
Lordship, a summary has been given. Lordship may be pleased to take up the IA, annexure 1, page 74, Lordship. I have given the list of the entities. All the
Okay.
partners' name, each and every detail has been given.
Page number?
Page number, Lordship, 74 of the IA.
Yes.
Yes, entities, Lordship, page 74, all the firms, all the companies, all the LLP, and Lordship, who are the partners or directors, I had given the list, Lordship. I have thereafter, I have annexed all the partnership deeds of the firms, Lordship, from page 76
Okay.
onwards. So, Lordship, this is a very, Lordship, the non-consideration of the MU by the learned trial court and the non-consideration of the third-party interests who are not the parties to in the suit is a perversity at large on the face of the record.
Okay.
And your Lordship, be pleased to, even then your own Lordship, for maintaining the goodwill of the companies or firm, Lordship, I do not want freezing of the accounts, Lordship. So my humble submission, limited submission is this, Lordship. Manoj Kumar Jalan, other partner directors may authorize Manoj Kumar Jalan for check transactions, Lordship, monetary transactions. I have no objection, but only my signatures should be also there because I am the partner director in all the entities. That is my only limited purpose. And Lordship, apart from that, single group, that is the petitioner plaintiff, they are the majority shareholder. 70%. Defendant, respondent, they are in the minority shareholder, Lordship. I have given all these facts here. So the majority shareholder has been ousted. He has been deprived from signing the checks. And bank is not cooperating. Bank is running the accounts without having the KYC revalidation. The judgments and the RBI guidelines I have placed before your Lordship.
Okay, yes, Mr.
So my humble submission, this is a fit case to be interfered, Lordship. And if my learned friend agree that all the other partners, directors may authorize Manoj Jalan, I have no objection. But there should be my signature also, Lord, to check the siphoning of the money, Lords.
Yes, Mr.
May
Deep.
please, my lordship. My lord, first point would be, my lord, the order impugn, which is 8/5/2015, had merely deferred the adjudication of the injunction application. It has only declined to pass an ad interim order in terms of the proviso.
Yes.
Now that the notice period is over and we've already appeared, in my respectful understanding, nothing's arrived in this appeal. My lord, secondly, my lord, insofar as the appeal is concerned, besides finding fault with the judgment or ad interim order, my lord, because setting aside the order perhaps will not satisfy them, they want an injunction from this court as well. So besides finding fault with the judgment, they also have to perhaps show that they were indeed entitled to an injunction. So
Ex parte.
injunction on that particular day. Now, my lord, I'd like to clarify a few positions here at the very outset. It is not a dispute as is being projected between the two families. It is not as if it's a dispute between the Singhal family or the Jalan family. In fact, I am also holding the brief of the own brother of the petitioner, who is arrayed as respondent number 3 here, Vivek Anand Singhal. So it is only the two petitioners who are against the other partners, and it cannot be projected as a Singhal versus Jalan dispute. Because Vivek Anand Singhal, and in fact, even the grandmother who's not in the fray, is, according to me, with us. Number 3, respondent number 4, your lordship will mark. And how this suit was even filed without board resolutions on behalf of the companies is not comprehensible. Of course, I'll urge that during the trial, my lord, but that is something which your lordship will perhaps take note of. That this suit has been filed on behalf of the companies. And as it appears from the cause title, there are just 2 individuals who are espousing the cause. There are no board resolutions empowering those 2 individuals to start off, to sort of initiate with the dispute. The proceedings. Lord, let me address the issue of that conciliation award right at the beginning, because
MOU.
major thrust has been given on that.
Yes.
Now, since I've clarified that this is not about the 2 families, so therefore that settlement is quoted out of context in the sense that they cannot be seen to be representing the whole of the
Single family.
So therefore that MOU will not be decisive insofar as this dispute is concerned. Secondly, my lord, if that is indeed a conciliation award, my lord, like they want to project, then how is the suit even maintainable? Because if it's a conciliation award, it has to be treated like an award under section 30 passed by the arbitrator. In which case, the enforcement has to happen by way of section 36 and not by a separate suit. Your lordship will kindly have the arbitration act.
Yes,
Section 74, if your lordship has. Status and effect of settlement agreement.
just a minute. Yes,
Now, this is part of part 3, which deals with conciliation. 74 says, status and effect of settlement agreement. The settlement agreement shall have the same status and effect as if it is an arbitral award on agreed terms on the substance of the dispute rendered by an arbitral tribunal under section 30.
so enforcement has to be under 96.
Yes, correct. So the suit if they insist that this is actually a conciliation award, then they have to sort of admit that the suit itself is not maintainable. Now, the settlement award is dated 23/9/24. And if your lordship has the IA, my lord, your lordship will find the entire cause of action has arisen thereafter when they approached the bank to freeze the operations. In fact, freezing was done twice at their behest, my lord, and both after the conciliation award. If your lordship has page 140, my lord, of the IA, I'll be mostly referring to the IA, my lord.
140.
I'm sorry. Oh, I'm sorry, 140. 140.
140.
Yes.
Yes. What is this?
This is the letter by which the petitioner had sought freezing of the account. The relevant portion your lordship finds at the foot of that document, my lord. Last but 3 lines. I hereby direct you to freeze all bank accounts immediately of Protect Group's all sister concerns, companies, partnerships until further investigation is going on. This also means the check online transaction through respective accounts debit freeze only. Then the details on the following page, the details of the bank account is given. So after this, my lord, the bank froze the accounts. Thereafter, there was a consensus arrived, and there was, in fact, a settlement arrived among the parties that Manoj Kumar Jalan alone would sort of operate the account, and the petitioners also endorsed that position. So page 143, if your lordship has, disputes were brewing, my lord. At their behest, the account was frozen. Thereafter, my lord, they arrived at a settlement at page 143, if your lordship sees.
Yes. Yes.
Now, if I may read that paragraph, my lord, in continuation of our earlier email and correspondence, and in reference to the captioned email, as stated herein above, we hereby confirm that Manoj Kumar Jalan Partner Pride Realty is the authorized signatory for the operation of the aforesaid accounts with your bank. And the signatures your lordship will find, the petitioner himself has signed, this signature is not disputed. So this was the position as on 18/5/2024. They themselves endorsed that there'll be just one signatory, and that is permissible under the agreement also, which I'll shortly indicate, my lord. And they authorize one single person to operate the account. Then, my lord, at page 149. (149), my lord, this is 10th of December 2024. After the so-called conciliation award, my lord, they again write to the bank at page 150, your lordship will find that request for freezing.
So
After the settlement.
after, no, before this, on joint application, it was defreezed.
It was defreezed. I was authorized to operate the accounts. Then there was again some fresh dispute. And post the so-called conciliation of word, they again reapproach that the account should be refreezed. And that is that is what your lordship felt, that request at page 150 towards the last paragraph. The underlined portion.
Yes.
You can then please freeze the respective bank accounts until further investigation by the authorities. And accordingly, based on this request, at page 153, your lordship will find 13/12/2024, the accounts were again freezed, the operations. This is again 13/12/2024. Page 153.
Yes. 153 again defreeze.
At their request.
No. 150, the prayer was made for freezing.
Yes, my lord.
Thereafter,
The bank
Page-
again froze it on
page
13
153.
page 153. Now, this was at that particular point of time only in respect of one entity, which is Pride Realty.
Yes.
Now, this caused panic because ultimately if the accounts are frozen, how do we even carry on with the business operation? Now, compelled, we approach because all the partnership deeds have an arbitration clause. So compelled with this conduct of the petitioner and the bank's action in freezing, we were compelled to file an application under Section 9. Now, Section 9 order, if your lordship sees, page 170. It begins from 157.
This misarbitration
Yes.
205.
This is it. Now the operating portion, your lordship finds at page 171. 170 onwards.
Yes.
Para 15, number 1.
This order is on your section 9 petition.
Yes, is on my Section 9. After the refreezing, I had to go to the court seeking interim relief, and this is the interim relief that was done.
Yes.
15.1, an order of ad interim injunction is forthwith defreeze the current account number so-and-so of the petitioner held with the OP number 2 IndusInd Bank, Ganeshguri branch, and debit payment request made concerning transactions of the said account prior to the date of freezing. Number 2 is important, my lord. An injunction to restrain the OP number 1, that is the appellant, my lord, from taking any action steps for closing, freezing of the transaction in the bank accounts of the petitioner number 1 post defreezing of the said current account of the petitioner number 1, and from taking any steps from freezing the accounts of any sister companies, subsidiaries, or the parent companies, firms of the petitioner. So given the conduct where the repeated request was made to freeze accounts and they themselves go and say, no, we authorize Manoj Kumar Jalan, given this conduct, the order was very clear. First of all, the already frozen account should be defreezed and he be restrained from taking any steps from initiating again freezing of the other, of not only the account of Pride Realty, but of all sister concerns.
Okay.
Now, this brings me to the next point, my lord. If the order as prayed for is granted, will it not be in conflict of an order already passed in the Section 9 application? Because this already has restrained them from taking action for freezing or sort of hinder operations through us, my lord. So if the injunction as prayed for in the current suit is granted, that will be in clear conflict of the earlier order.
What is the status of
This is still
misarbi-
pending. Now,
At what stage they have appeared?
they have appeared. They
They
have
have
appeared.
filed
It is at
objections.
the stage of final hearing. Tomorrow. So if I have indeed suppressed the settlement agreement, which was a suppression of material fact as they now allege, then they are supposed to go and urge it before this court.
If the
Hello.
this court in that court where arbitration case is pending vacates the order, there would be no necessity of
Exactly. Madam. Exactly. Madam. And in fact, that is what I wanted to show, that this is in fact a case of forum hunting. If your lordship takes up page 299 of my, it's in the same IA, my lord. 299 annexure C.
yes, what is this?
Now they have appeared in the section 9 application. They have moved an application for modification of the order that I just shown, my lord. And the prayers, your lordship will find, are identical to the prayers made in this IA, my lord, page 342.
Yes.
Substantially the same, my lord, if not identical. Page 342, if your lordship has.
Yes,
The prayers in that application are all withdrawals, debit instruments, online and offline from the bank accounts of all the entities of the Protect Group and its sister concerned subsidiaries with the OP number 7 IndusInd Bank and any other bank must be done after obtaining all the partner signatures of all the partners in case of firms and all the directors in case of the companies. Now this is, if not identical, my lord, this is substantially the same as the prayer made here in this IA, which the prayer which your lordship finds at page 69 of the IA.
okay.
So, my lord, first, if this order is granted, it will be in conflict with the earlier order.
It may be in conflict.
Hello?
It may be in conflict.
It will be in, if it is granted, my
Oh,
lord.
if it is granted.
If it is granted, it'll be in, firstly, it'll be in conflict with the order passed under section 9. And secondly, these two similar prayers are are urged simultaneously in two different proceedings, one in an arbitration proceeding and in this proceeding by way of a separate suit. So therefore, and this is prior in point of time, and unless that order is either modified or vacated, my lord, this fresh order cannot be passed because both the orders will then operate in the same field. Now, my lord, coming to the partnership deeds itself, my lord, if your lordship sees page 82
Of the,
of the IA, I'll be referring mostly to the IA. Page 76, the partnership agreements starts, my lord.
page number,
Page 76, the deed starts, my lord. I'm
Which
referring,
page you are referring?
page 80, my lord.
80.
80.
Yes,
Paragraph 9, my lord. that the bank account of the firm shall be kept in the name of the firm with any of the scheduled or nationalized or any other bank and shall be operated by the parties hereto of the first, second, and second parts severally or by any other person or persons authorized by the said partners on that behalf. These partners may also arrange loan, overdraft, and cash credit facilities or such other banking accommodation for and on behalf of the firm as may be necessary for the purpose of the business of the partnership firm. So there is a provision in the deal which enables the partners to agree on one partner who operates. And that consensus was already there, like I had already shown at page 143. They too endorsed that respondent number 3 should operate.
Now, after last defreezing,
Yes, Manoj.
on what authority bank has allowed Manoj Jalan only to operate? The 143 or the document shown by them?
No, Manoj.
They have shown a different document.
Manoj, even otherwise, Manoj, bank cannot now that the order stands in my favor in the Section 9 application, there cannot be a refreezing again because bank is
Yes,
already obliged to
No.
allow me.
but on what basis the bank has allowed only a single partner to?
My lord, I was the partner who was operating it from the very beginning. Now, thereafter, they came up with allegations of misappropriation, which is why it was freezed.
Yes, thereafter.
Thereafter, they went and said that we agree that respondent 3 only should operate.
And
That authority-
they also signed in that.
They also signed. And that authority was never specifically revoked, my lord, but then they went ahead and said that no, there are large scale anomalies, therefore you refreeze.
So on the basis of the earlier authority,
I continue, and now that my position is fortified by the Section 9 order, I continue and bank is obliged to allow me to operate. And he in fact is restricted from raising any objection by virtue of that order. So everything in my respectful understanding depends on that order and that Section 9 application. And these questions have to be necessarily decided there. Perhaps your lordship will rise.
okay, he'll continue.
I'll continue.
I'd like to give my reply.
But he will not get much time for that.
No. Short reply I will give.
Let me
And a
conclude.
bank has to also.
Yes, add to it.
Apply.
Okay.
Lordship, sorry, Lordship. I am along with my brother. We are item number 6. Item number 6, your Lordship, it will take time. This so far the item number 4 is concerned. So
Sir,
I am not feeling well.
My lord, the substance question law has been supplied today, my lord. So it may be fixed on 6th, my lord.
6.
Yes.
Heard Mr. R.K. Bhuya, learned counsel for the appellant. Also heard Mr. G.N. Sahiwala, learned senior counsel assisted by Ms. S. Todi. Learned counsel for the appellant has sought for an adjournment on the ground that he is not feeling well. The prayer for adjournment is not opposed to by learned counsel for the respondent. Let this matter be listed again on 6th of November.
No.
My lord, I had submitted prior to the break, my lord. A, the appeal has become in a way infructuous, nothing survives. B, passing the order as prayed for would amount to passing a conflicting order, which is already operating in the Section 9 application.
And that order has not been impugned anywhere.
That order has not been implemented.
Challenge.
And it cannot be also challenged in a
Yes.
parallel proceeding. Thirdly, the same prayer is also pending in that Section 9 application, which I've already shown, which is similar to the prayer in this I. Where they-
By
By the-
filing the
Application.
in the objection or a separate
a
application.
separate application by them for modification of the order, and the prayers are virtually the same.
Yes, that modification prayer is at page number.
That modification prayer is at page 299.
Okay, okay.
299, the prayer is at page 342.
Yes, I have gone through.
So 342, page numbers 342 and page 69 if
Page
you're
69
for
are
lordships.
contradictory.
No, are the same.
Are same, sir.
Are same. And lastly, insofar as the conciliation award that was stressed on, my submission would be number one, if there has been a conciliation award, then a separate suit will not be maintainable in terms of section 74. The conciliation award does not contain any stipulation regarding the banking activities, which is the moot subject matter here. And conciliation award is vis-a-vis the two families, and therefore the petitioner number 1 and 2. Three petitioners herein cannot alone claim the entire benefit of that particular conciliation award. Now moving on, my lord, to the partnership deed itself. I was at page 82, my lord, 80.
Yes.
Page 80,
Para 9.
para 9 clearly stipulates that there can be a situation where when one partner is authorized to operate the bank account. Now, the following page, at page 82, if your lordship takes up.
Yes. Page 82.
Clause 20. All disputes concerning the partnership affairs, if cannot be settled mutually, shall be referred to the arbitrators to be appointed under the relevant arbitration law in India. And all agreements annexed to the IA clearly show that it's an arbitrable dispute. Page 96 is another example. This is an arbitrable dispute. And one proceeding under the Arbitration Act is already pending. It is at this juncture that they moved a separate suit. Now, my lord, at page 289, your lordship will find that we have appeared in
No,
the
page 96, what you are referring?
page 96, clause 21 is another partnership firm, another arbitration agreement.
So in every partnership deed
There are arbitration clauses.
clauses. Okay.
Now, in terms of this arbitration clause, we have already moved because we must do it before we file our first statement of defense. We've already made that application for reference to an arbitration before the trial court after we appeared. That is at page 289. Our application under section 8 for reference of the dispute to arbitration.
Yes.
Now, your lordship is aware of section 5 of the Arbitration and Conciliation Act, which says that the extent of judicial intervention should be minimal. And it should be in consonance with that part 1 of the act alone.
Yes.
Section 5, notwithstanding anything contained in any other law for the time being in force in matters governed by this part, no judicial authority shall intervene except where so provided in this part. So judicial intervention is possible only in terms with section 9, in terms with section 36, in terms with section 34. And no separate suit would therefore therefore lie in a case where the parties are governed by an arbitration clause. Now the question arises, we have moved the application under section 8. Section 8, I will not trouble your lordship, but your lordship is aware that the language in section 8 is preemptive. That the moment court finds that it's an arbitral dispute, it will sort of section 8.
Yes.
A judicial authority before which an action is brought in a matter which is the subject matter of an arbitration agreement shall, if a party to the arbitration agreement or any person claiming through or under him so applies, not later than the date of submitting his first defense on the substance of the dispute, then notwithstanding any judgment, decree or order of the Supreme Court or any court, refer the matter to arbitration unless it finds that prima facie no valid arbitration agreement exists. So the words are,
What has happened to your section 8
it is
petition?
pending, it is pending.
Okay.
Now the question therefore arises, should that question not be decided first before an application for interim relief can be considered? Because I've done my part, I have appeared before the court, and before filing my first statement of defense, I've pointed out that this is the position, it's an arbitral dispute. So therefore, given the preemptory language, should the court again see whether it can retain jurisdiction and grant an order of injunction? Now that aspect was dealt with by a few authorities. I'll just place one by our High Court. Now, what happens after once an application under section 8 is filed, that application should receive precedence because the court will first decide whether it can retain jurisdiction or not, only thereafter decide other issues. Para 24 onwards.
Yes.
Just to indicate that, my lord, here what had happened, someone moved an application under section 8, my lord, saying that it's an arbitrable dispute. Thereafter, the plaintiff moved an application under order 6, rule 17, so as to ensure that they can somehow wriggle out of that arbitration clause. The court said that you must decide the once that request has come under 8, all other things aside, that should be given precedence. Now, para 24.
What will happen in case of an urgent relief? Section 9, they have to move.
They have to prefer section 9.
Okay.
Para 24, my lord. In Pink City Midway Petroleum Supra, the Supreme Court reiterated the proposition that language of section 8 being preemptory in nature, where there is an arbitration clause of the agreement, it is obligatory for the court to refer the parties to arbitration in terms of their arbitration agreement, and nothing remains to be done in their original action after such application is made, except to refer the dispute to an arbitrator. In Sundaram Finance, the same proposition is again reaffirmed when the Supreme Court stated that where there is an agreement between the parties to refer the disputes or differences arising out of agreement to arbitration, and in case either of the parties ignoring the terms of the agreement approaches the civil court, and the other party in terms of section 8 moves the court for referring the parties to arbitration before the first statement on the substance of the dispute is filed, in view of the preemptory language of section 8 of the Act, it is obligatory for the court to refer the parties to arbitration in terms of the agreement. In Sundaram Finance Supra, another dimension was added with regard to the approach that should be adopted by the court while considering an application under section 8. The Supreme Court laid down that once an application in due compliance with section 8 of the Act is filed, the approach of the civil courts should be not to see whether the court can still retain jurisdiction, but to see whether the jurisdiction is ousted. In Hema Khattar, the Supreme Court stated that the civil court has no jurisdiction to entertain the suit after an application under section 8 of the Act is made for arbitration. It is further held that in such a situation, refusal to refer the dispute to arbitration will amount to causing irreparable injuries to the parties. para 31 then, my lord. Coming to the legality and validity of the order dated 15/11/2017, I am of the considered opinion that after an application under Section 8 is filed, court cannot expand its role to find out on the basis of the application filed subsequent to the filing of the application under Section 8 as to whether such application, if considered favorably, would vest the court with jurisdiction to proceed with the suit. The Supreme Court has made it clear that the approach of the court should not be to find out if the court can still retain jurisdiction, but to see whether its jurisdiction is ousted. This is the paradigm shift in the approach to be adopted when an application under Section 8 is filed. Going by the dicta in Hema Khattar, where the Supreme Court had unequivocally observed that civil court has no jurisdiction to entertain the suit after an application under Section 8 is made, any entertainment of any application subsequent to the filing of the application under Section 8 would be akin to the court continuing to entertain the suit, which is not permissible in law. That will amount to tantamount to a court exploring and embarking upon an inquiry to find out whether it
So
can
after
retain
Section 8 application is filed, that application has to be decided first.
first. Because ultimately, any orders passed would possibly be without jurisdiction. Because if going by the language of Section 5 and 8, it is preempted. So therefore, the court must first decide whether the arbitration clause is applicable, whether the parties should be referred, and only if it is prima facie satisfied that no prima facie valid arbitration agreement exists, only then it will refuse to refer and then continue with the suit. So that application is pending before the trial court. And therefore, my lord, another aspect I must point out is that in this particular appeal, your lordship will only examine whether on the basis of the materials that were available before the trial court on that particular day, the order could have been, the order is good or bad. Now, my lord, all of this KYC details, those banking circulars have come to this court for the first time by way of additional affidavits, those letters, etc. So therefore, when the trial court did not have the occasion to consider those additional documents which are placed here for the first time, should the court embark upon an exercise to see whether these additional documents could have justified an order of ad interim injunction?
And these were not before the.
These were not before. In fact, they were filing additional affidavits until yesterday, day before yesterday.
That's subsequent event.
These are subsequent events. Like my. And I have today, my lord, I have not even filed my response, my lord. Now the court, I am yet to respond to these allegations made in the additional affidavit, because I think there are 3 in total. So therefore, to redecide the application for injunction on the basis of these additional documents would gravely prejudice me. I haven't had the opportunity so far. Now I'll slightly move on to a few factual aspects, my lord. Like I've already in fact shown that this was the conduct. I can agree the Partnership Act says that all partners must be given an opportunity to participate in the affairs of the business. That is the mandate of the Act. But there are exceptions, as in when a partner acts in bad faith or in wanton breach of the conduct or the partnership agreement, as the instances where one partner sort of approaches the bank to freeze the account, that conduct is sufficient for the courts to step in and even sideline a partner, though he may still be a partner. Now, this conduct I have already shown. You may have differences within the family, outside the family, within the partnership agreement, but will you jeopardize the business itself by sort of freezing the operations of the bank account? Because ultimately the welfare of that entity is of paramount importance. There could be disgruntled partners here and there, but that doesn't mean that the business affairs should be stalled altogether. And your lordship can imagine, like my learned senior friend has already submitted, this firm carries out a lot of sort of real estate projects. Now they require sort of regular debit transaction, etc. Now, if those debit transactions are brought to a standstill, that is their precise idea, because initially their intention is very clear. First, they wanted to freeze, then they sort of tried to arm twist, and then a settlement was arrived. Then they again said that we are okay with Mr. Jalan operating the bank account. Then they again make a volte-face and again go for freezing of the accounts. And now they are saying that we don't want freezing. All we want is I should also countersign the checks or the transaction. Now the idea is apparent, my lord. If I go for their endorsement, they'll not sign it, and ultimately the transactions would stop. So that is the precise idea. So the question is, given this conduct, was an interim order in their favor necessary, or whether that Section 9 order is the justifiable course of action that should be taken, although that is not a subject matter, but nevertheless, if I may just place two High Court judgments, my lord, dealing with this subject. But here the English authorities were discussed, and para 30, your lordship finds the relevant portion. 1981 SCC Online, Delhi 12.
Para 30.
Para 30, 30.
Yes.
My lord, I'll skip the first two sentences. The fourth line, as shall be. Para 30, the fourth line, as shall be. As your
Yes, yes.
As shall be presently seen, the defendants persist in conducting themselves so wantonly so as to render it impossible for the business to be carried on in a proper manner. It matters not whether they are doing so in violation, breach of any specific stipulation in the partnership agreement or otherwise, for the fact remains that all partners furnished personal guarantees to the bank concerned for granting them overdraft facility to the tune of so-and-so, and the same has been operated upon by the plaintiff consistently and continuously ever since the inception of the partnership business. So is the case here, Malak. Clause 9 of the partnership agreement clearly enjoins upon all parties to be just and faithful to each other and to render true account and information of all things affecting the firm to any partner. So the conduct of the defendants in writing letter dated 30th August 1979 to their principals to suspend supplies of vehicles and parts of the to the partnership firm clearly constitute an act in bad faith. They did so at the back of the plaintiff, obviously with a view to undermine and impair his position as a managing partner. Even otherwise, this action on the part of the defendants was injurious and harmful to the business of the firm. Not only that, they wrote to their banker, Bank of Rajasthan Limited, that a dispute having arisen among the partners of the firm, they, the bankers, should not honor any checks issued by any partner in the firm's account, and the authority to operate the account by any of the partners jointly or severally be treated as suspended. Similar conduct, madam. This kind of wanton and unruly act was bound to recoil and boomerang on the business of the partnership, as would be evidently clear from the letter dated so-and-so of Mahindra and Mahindra to the defendant firm. In the said letter, the principals of the partnership firm made a grievance of the fact that the banker had declined to negotiate documents under the letter of credit opened by them, even though the same was irrevocable. So they threatened the partnership firm with immediate cancellation of the franchise. It is a different thing that subsequently some kind of settlement was arrived at between the parties and the plaintiff continued to conduct and manage the affairs of the partnership as before. However, the differences and disputes between the two groups of partners were so deep-rooted that the settlement proved to be short-lived and litigation ensued between both with regard to the partnership as well as Messrs. Supreme Motors, the other family concern of the parties. Hence, it is absolutely imperative and essential that steps be taken by the court to preserve the business and goodwill of the partnership till it is dissolved by consensus among the partners or some other viable solution is found. Certainly, the comparative mischief or inconvenience which is likely to issue from withholding injunction will be greater than that which is likely to arise from granting it. Para 35, my lord. Para 35, my lord, somewhere in the middle, the sentence starts from as already seen, as your lordship found it. Should be 13th line, my lord.
Yes,
As
yes.
already seen, the defendants fired the first shot by writing to their principals and bankers for suspending supplies of the vehicles and credit facilities. That certainly constituted wanton misconduct and breach of good faith. And if I may say so, a suicidal act on their part in relation to the partnership business. Surely the plaintiff as a responsible partner has a right to require them to discharge their duties as partners faithfully and diligently. They can hardly be allowed to stab the partnership business in the back and destroy it altogether by undisciplined and irresponsible behavior. So, my lord, in fact, this was very dangerous in the sense that now with the coming of the RERA Act, I have specific deadlines to meet in respect of all the projects that I undertake, and I as in all of us. So ultimately, if you choke the entire business by curtailing the flow of funds, then I will not be able to, the firm as a whole will not be able to sort of meet those deadlines. So therefore,
At the first instance, when the account was freezed for the first time
yes,
on his request.
Yes.
What were the contentions? Why he?
Contentions are varied, my lord. They have alleged that his brother sort of misused the power of attorney given by him. Then he says that the members of the Jalan family had siphoned off funds from this project to projects belonging to another firm called Ambika that is run by me. I can understand there being differences, my lord. Ultimately, even if there are differences, ultimately it has to be resolved by arbitration, and there can at best be a dissolution of the firm or a rendition of accounts. But to sort of cripple the business of a going concern by stalling all banking transactions will be an action in bad faith, ultimately, warranting an injunction.
What is your response to the submissions made by the counsel for the other side? That as the MOU entered into between two families itself can be regarded as an award. The arbitration and the matter could not be referred to arbitration.
My lord, if that is so, I can come. That is a double-edged sword. Ultimately, if there is a settlement, there is a conclusion of the dispute. Let me answer it this way. If there is a conciliation award, the dispute has ended. If the dispute has ended, you must come through the proper channel, that is to implement or enforce that particular award. That is number one. If the dispute had ended in September of 2024, then why did they again write to the bank in December 2024 to freeze the account? So that means the settlement was never acted upon, even by then. Thirdly, this particular settlement merely said that this family will have this much, this family will have this much. It did not really stipulate that how the accounts are to be handled, who will manage the accounts, who will be the authorized signatories in the account. So that dispute arose subsequent to the settlement award. Even if we, let me however make it clear, my lord, we have not yet admitted the whether that conciliation award is effective or not. because that's a one-page award, and to ensure shareholding patterns to be rectified on the basis of that one-page conciliation award, as they call it, would perhaps not even be possible. So, and I'm yet to respond to that as to whether this particular conciliation award is still in force, whether we are bound by it, or by the owing to the fact of your subsequent conduct itself nullifies that award. And all said and done, this issue regarding banking transaction, there is no stipulation there. Now, my lord, the other judgment of Modern Metal Industry.
Vera,
Para 47.
yes.
In paragraph 18 of his affidavit before the court, appellant number 2 has categorically stated that the respondents took the action of sending letter dated 3/10/2003 for stopping payments to the bank without any notice or information to the appellant number 2. In their reply to the same, in paragraph 17 of their counter affidavit, the respondents have, while not denying the contents of the said paragraph 18, only sought to refer to the advocate's notice, so and so. So here also a request for stopping transaction was made. The said advocate's notice does not even remotely mention anything as regards the action of stopping payments of the bank account, and in any case, it was received by the appellant 2 only on 6/10/2003. The fact regarding receipt of the notice on 6/10/2003 stated by the appellant number 2 in para 20 of her affidavit remain unrebutted by the respondents in para 18 of their counter affidavit. Hence, it is evident that before their letter dated 3/10/2003 was sent to the bank, the respondents never gave any notice or information of the same to appellant number 2 to enable him to exercise his right of expressing his opinion on the subject and be consulted under section 12 of the Act. In our opinion, the view taken by the court below that the mutual indivisible adhesive bond of trust, faith and confidence which created the partnership and the firm has evaporated is wholly misconceived. Had the respondents truly and genuinely lost faith, confidence in appellant number 2, they would have dissolved the firm and wound up its business, because they have neither done that nor even taken any steps before any court for the redressal of their so-called grievances. The court has unduly got carried away even in the absence of any case on merits being put before it by the respondents. In our opinion, the court below has failed to exercise its discretion reasonably and legally by not granting the interim relief against the respondent. It has failed to appreciate that while on one hand the agreement and business among the partners as per the partnership deed is continuing intact, and therefore all partners both contractually and legally stand still mutually bound to one another and committed to the welfare of the partnership concerned. On the other hand, respondent number 1 and 2 are continuing to commit breach of the partnership deed and agreement by their wholly reckless, irresponsible, high-handed and non-cooperative acts, including the act of getting the payments from the bank account stopped. Para 57, my lord, then after. Page 16, para 57.
Yes.
In the present case, as already mentioned above, although the partnership agreement stated that the bank account can be operated jointly and severally by all the partners, subsequently by conduct, the partners had agreed that the appellant 2 alone will operate the firm's bank account, similar to our case. To our mind, the reason for this was obvious. The respondent 1 and 2 were living with the families in Calcutta, while the business of the firm was at Kanpur. The 2-day affairs, the running of the business required making payments from the bank account for various
business purposes. And obviously, if every check of the firm has to be signed by all three partners, the functioning of the firm would become impossible because the checks would have to be sent for signing to Calcutta and then return, and all this would have caused delay. Hence, it is obvious from the facts that when the relation between the parties were good, they impliedly agreed that the appellant number 2, who was residing at Kanpur and looking after the business of the firm, should have authority to operate the bank. In Const versus Harris, it was further observed, I call that act of all, which is the act of majority, provided all are consulted and the majority are acting bona fide. In the above decision, Lord Chancellor also observed, for a majority of partners to say, we do not care what one partner may say, we being the majority will do what we please, is I apprehend that what this court will not allow. So again, with respect to making
To
Robert.
emphasize what point you are referring to this judgment.
In this
That in
judgment,
the instant case also, the partners have authorized.
had authorized, maybe impliedly, because Mr. Jalan was handling the banking transactions throughout till when that request for freezing was made. And then there is another acknowledgement in the form of that letter dated letter at page 143.
Now the bank
Yes.
is not bound by the authority, but by the order 9,
Yes.
order under section
Section
9.
9. So unless that has been, that is modified, ultimately
Bank is bound.
bound. And therefore their remedy will not be by way of a separate suit, but to get that order vacated, more so when it is clearly an arbitrable dispute.
Okay.
And ultimately, the learned trial court has thoroughly discussed the provisions. We are all aware of the limitations of an appeal against a discretionary order of injunction. Now, and given the nature of this appeal, because even if your lordship sets aside that order, ultimately injunction will not come automatically. They'll have to again, perhaps that is why the IA is filed. So IA is of importance as compared to the appeal, because even if they succeed in satisfying your lordship that the order was for some reason bad, it may just amount to setting aside of that order, but that automatically will not entitle them to an injunction.
Okay. But we are deciding the appeal,
Yes.
though you have not filed your
Right.
counter to the additional affidavits.
I've not filed.
But you have made submissions to that effect.
I have made some.
Oh.
And ultimately, proviso to Rule 3, it's a court's discretion when it thinks that the object of granting an injunction would be defeated by delay. Only then an ad interim order is called for, which is a rarity. I did not place any authority for that, but ultimately proviso has to be sparingly used. And at the stage of ad interim order, perhaps it'll be too much to say that the trial court has to sort of record everything that has been written in the plain so as to decide prima facie case. Ultimately, it has not taken a final decision. It has merely
It has
said
only refused ad
ad
interim,
interim order. That's it.
but it has not rejected the prayer of.
It has left the adjudication open.
Okay.
And now that we've appeared, what survives here, Manu? Ultimately, the same exercise need not be done twice. If the trial court is already in session of the matter and that period is gone, and your lordship will mark to ad interim orders are granted in cases of extreme urgency, my lord. Let us assume there was extreme urgency on 8/5/2015. Today we are on 30th of October 2025. Because ultimately this appeal is only concerning whether that discretion under the proviso is to be exercised or not.
Yes.
So from May 2025, they waited till October 2025, and the matter is now before the trial court, where it has to first decide whether it can at all retain jurisdiction. Should the court at this juncture interfere,
And that discretion where it is seen whether defeat the delay, that delay is to be reckoned to be the delay in serving the parties with notices.
Yes.
And we've surpassed that stage. Well, on facts, there are several other aspects, but I would like to refrain from going into those aspects because ultimately, whatever orders are passed, if those facts are delved into, my lord, it may prejudice either of the sides before the trial court. And at a stage where I'm yet to file my objection in written statement.
Okay. Yes, bank.
My lord, my respectful submission to your lordship is that, my lord, from the pleadings made by both the parties here, my lord, it is clearly seen that it is a totally a private dispute, my lord. It's a dispute between the partners of the farm or director of the company. And bank has no role to play in this private dispute between the parties. We are surprised why the bank has made a respondent number 1 and 2 here, or defendant number 1 and 2 in the case. The bank is a regulated entity. It has to abide by the guidelines framed by the Reserve Bank of India.
No, what is your response to the submission that
And
you
my
have,
response
you,
is-
you have violated the RBI guidelines?
My lord, I am coming.
In-
My lord, the role of the bank comes to play when the first letter of freezing is served by the party. That is on 14/5/2024. The appellant herein, my lord, he has issued a letter notifying some financial irregularities there in the partnership or in the
And
company.
accordingly, you freezed.
We have freeze, my lord. Then again, there are multiple letters issued by the both parties with their signatures. They have near about 10 or 11 entities. So all entities has given a letter to the bank that the dispute has been sorted out. So Manoj Jalan has been given the authority to sign the accounts. Basis on that, my lord, the bank has defreezed the accounts. It was in the 18/5/24, the letter was issued by all the partners have jointly signed there. Then on my lord, 10 December 24, again, one of the partners come that there's a dispute arising again with this accounts. Then bank has again marked freezing on this account. Thereafter, this party has gone to this court below with the section 9 application and got the order of injunction, my lord. So, my lord, thereafter what happened? The bank has, in the meantime, 21 December 2024, bank has issued a letter to Protect Housing for clarification in charge of who is the in charge of partnership. With regard to the partnership, it should clarify. My lord, please. Annexure 30, page 173 of IA.
Page 1.
173. Annexure 30. This is a letter issued by the bank to Protect Housing, Partnership Firm, and all the partners of MS Protect Housing. The letter content is, yes, sir, madam. This is to inform you that the bank is in receipt of letter dated so and so from Lokesh Singhal, claiming to one of the partners in your firm, namely so and so, along with deed of admission of new partner dated so and so. He has further mentioned about mismanagement in the conduct of business of the said firm and requested the bank to freeze the caption bank account. Copy of the admission of new partner dated so and so is enclosed herewith. So, my lord, by this letter, in this second last paragraph, in this connection, we hereby call upon you to please confirm whether there is any change in the partnership firm, namely MS Protect Housing, along with supportive documents. So this is the first letter, my lord, the bank has issued for submitting the details of the partnership to the parties. Then, my lord, thereafter again on 6 January 2025.
Page number.
This is the letter submitted by Protect, my lord.
Page number.
No, it is not annexed here.
On 6 January,
6 January 2020, a letter by Protect. They have submitted certain documents.
The order under section 9 was passed on which date? This order was communicated to bank.
Yes, my lord.
When?
We have received the letter. After receiving of letter, now we have parallelly we are running the process of KYC, re-KYC, which was pending. They have initiated a letter, so we have asked the parties to supply the documents. By 6 January, they have not supplied the all documents, so bank has issued a reminder letter, my lord. That is Annexure B, page 403, my lord, of additional affidavit. The letter dated 9 January 2025, my lord, Annexure B, page 403 of additional affidavit, my lord. My lord, it is the content here, the submission of customer updates form and documents for account number so and so and so and so. Thank you for banking with us. We refer to you letter dated so and so. So here, my lord, the certain list of documents has been asked by the bank to furnish to complete the exercise of re-KYC. Here, my lord, you see the first, your lordship will see number one, the re-KYC for caption customer ID is updated with the bank on 3/9/2024. Number two, as mentioned above, as there is a dispute in the Protect Group stakeholders, RBI complaint and the interim court order will with bank letter dated so and so, bank has initiated the process of updating latest KYC documents for above mentioned accounts on top priority. With regard to a e-Aadhaar of signature, the submitted copy of e-Aadhaar is being
Okay,
accepted for
you
updation.
took, you took steps.
Yes, my lord. We have taken all steps here, my lord. Despite this also, they have not submitted the documents, my lord. Then again, bank has issued a reminder. That is in 15 January 2025. That is page 405. To protect
Thereafter,
housing. Here, my lord, we are delighted, the para 2, we
There-
refer to our letter.
thereafter what happened?
My lord,
They
again,
did
thereafter-
not responded.
Well, Protect has submitted some documents here again. But they have mentioned that few are pending at our end, we could not conclude it. So their part document is supplied to the bank. Then bank has again issued another letter, my lord.
When?
But in the meantime, my lord, kindly see the Annexure C, page 409.
Yes.
409, madam, second page, my lord, here in 410. The last, from the bottom of the third para. That several attempts have been initiated to amicably resolve the said differences. However, the same did not yield the desired results, and the matter is still pending for any resolution and is under subjudice of the Honorable Court of Law. As such, getting signature of the above named director partner in the re-KYC document as mandated in your bank letter so and so is nearly impossible. So it is a reply of the parties that we are not possible to supply all the documents because this is the reason. Then again, my lord, ignoring all the other earlier letters, my lord, bank has again given an opportunity, my lord. That is by letter 26/9/2025, my lord. The Annexure G, page 435, my lord. This is the second affidavit filed by the party, my lord.
Page number?
435, my lord. Annexure G. So 433, my lord, 433. Here, my lord, the bank has clearly mentioned serial number 3, my lord. Mode of operation letter to be signed by all partners as per latest deed.
No, where is that second affidavit? In
Page
the-
433, this is second affidavit filed by the appellant,
It is in the IA or
IIA, my lord.
it is not there.
No, recently they have filed this affidavit, just day before yesterday. Page number 433. Additional affidavit it is.
It is whether, is it on record?
Additional affidavit.
Okay, okay. No, their submission is that when they fail to furnish the KYC details, as per RBI guidelines, you should have suspended the account. What is your response to that?
So here, my lord, the bank response is that, my lord, they have issued the letter, before this, my banker issued another letter, asked the parties to come to the branch on 6, 7, and 8 of this September. They've given 3 dates, mentioning the name of the branch manager, that to complete the exercise, you visit any of these 3 dates, 6, 7, 8 of September, and complete the exercise. So accordingly, they have visited, both the parties visited, they went to the office for submitting documents. Some has signed, some has not signed there, my lord. So exercise could not be complete on that particular day also. But this is a letter here.
So the process is going on. That
Process
is your,
is going on, my
that
lord.
is
It's
your
not completed.
submission. Okay. Okay, yes. Anything else?
My respect submission is that, my lord, the bank cannot unilaterally suspend the account because in the section 9 order, there is, order is there.
Now there is an order of the court. Section 9.
In the section 9 order here.
Anything you want to say?
Question is, we submitted all the documents, but they require signature of all the parties. Now, naturally, the interpretation.
Because of the dispute.
Still they're not coming forward. We have therefore made it clear that we'll get into everything except for the signatures of the petition. So they have in turn alleged that you have not reached out to me, therefore I've not. So it is in a limbo at that stage.
Okay. Yes. Any reply? You
Well,
have anything else to submit?
Man, on our part also, we are not able to bring all parties together. We have though issued letter. They have come one by one only. They have not come together to sign the documents.
Yes, Mr. Rao.
And their judgment also, man, I would like to support, in support of my this freezing and defreezing, my lord.
What it says?
The Allahabad High Court judgment, my lord, here it speaks, my lord, when there is a dispute between the partners, the bank cannot withhold the account to withdraw the amount from the bank. This is 2025 judgment of the Allahabad High Court, my lord. Here partners, the husband and wife, some dispute are going between them, the matrimonial disputes. So one of the
Yeah.
the para 2, kindly see, my lord, at page 2. On account of matrimonial dispute, third respondent made an application to respondent number 2, Kotak Mahindra Bank, hereafter referred to as the bank, for freezing the current account of the petitioner company maintained in its Ghaziabad branch till the pending matrimonial dispute is resolved. Respondent number 3 admittedly has a share of 0.75% in the petitioner company, whereas shareholding of the Rajiv Kumar Arora is 41.15 in the company. Para 3, my lord, the bank has acted upon the representation of the third respondent and has freezed petitioner's bank account number so and so by this order date so and so. By this communication, the petitioner has been advised by the bank to get their internal dispute resolved. Then para 4, my lord, the first line. It is at this stage that the petitioner is before this court for a direction to the respondent bank to defreeze its bank account and to allow it to operate its bank account. Then, my lord, the relevant portion, para 9, my lord. Para 9, my lord. Before the court proceeds to examine the petitioner's prayer in the writ petition, it would be necessary to examine the nature and character of the respondent's bank, as also the obligation imposed upon it to allow its depositor to withdraw its amount from the bank. As a necessary corollary to it has been seen as to whether the respondent bank, being a private entity, has the right to refuse withdrawal of amount by the depositor only because the director of the account holder company is facing a matrimonial dispute with his wife. So here, my lord, the court has realized that the dispute cannot give you a right to withhold the account. The next, my lord, the relevant portion of page para 26, my lord. Para 26, my lord.
Yes.
Admittedly, there is no order passed by any competent court to freeze the petitioner's bank account. There is no action or order of the investigating authority in any criminal case to freeze such bank account either. No provision exists in law conferring authority upon the respondent bank to adjudicate private claims of the director regarding their matrimonial dispute. Then again, my lord, in para 30. In para 30 from the bottom 4 line, the bank can deny withdrawal of such amount only in exigencies which are permissible in law. Such exigencies do not arise in the facts of this case, as is noticed above. In its absence, the action of the respondent bank in refusing to allow withdrawal of amount from the account of the petitioner company cannot be sustained. Para 31, my lord, next para. So far as the grievance of the third respondent in respect of private dispute between her and director of the petitioner company is concerned, her remedy would be to pursue her grievance either before the competent civil court or before the NCLT. Where such proceedings are admittedly pending, there are otherwise no request for stopping withdrawal of the amount in criminal proceedings. The third respondent, therefore, would be well advised to seek appropriate direction from the competent forum in accordance with law. Making request to the bank for freezing the account of petitioner company would not be proper remedy. We also hold that respondent bank has no jurisdiction to entertain the request of the third respondent and thereby freeze petitioner account and deny withdrawal of amount from the bank account of the petitioner. The concluding paragraph 32. In view of the deliberations and discussions held above, this writ petition succeeds and is allowed. The order passed by respondent bank dated so and so is quashed. The respondent bank are directed to allow the petitioner to operate its current account number so and so, maintain its Rajnagar, Bhavpur branch, district Ghaziabad, unless there is any legal hindrance created by a competent forum in terms of the above direction. So, my lord, here the bank is not on freezing or unfreezing. Bank is asking that you settle your disputes and come to us and tell us who is the authorized signatory. If you want single person, then you give the MOP accordingly. If you want all to sign together, you give the MOP accordingly. But they are not providing the particular document. So based on the original document, it is continuing with this Manoj Jalan now because of the dispute, my lord. These are my submissions, my lord.
Yes. Mr. Roy,
My lord,
brief reply.
my learned friend has submitted that the parties, they are not supplying the necessary document. Then I have submitted the Supreme Court judgment, our High Court judgment. In that event, Lordship, it is the bounden duty of the bank to keep the bank account operation in suspense. Transaction cannot be allowed, Lordship. The RBI guidelines also says so. This Lordship, the tenants manual for banks, Lordship, also provide the same thing. So why they have not acted? It means there is we have alleged in our plan, there is a great collusion between the private respondents and the bank, Lordship. Why they are not acting as per the KIC rules? Why they are not acting as per the RBI guidelines? Why they are not acting as per the bankers manual, Lordship? So this shows the collusive action between the.
No, but they are saying that it is you who is refusing to put your signatures.
No, no, Lord. I never denied. I submitted the documents, Lordship, and already I have placed with one surprising thing. Again, I would like to place before all Lordship. Lordship, please to take up the additional affidavit number 3. Additional affidavit number 3, page 451. How the bank is involved and acting at the behest of Manoj Jalan, this will prove.
Additional affidavit number 3.
Additional affidavit number 3, dated 28th October,
When have you filed it?
28th this month. The first of your Lordship has perused that.
My lord, these are the subsequent developments. These are not before the trial court below
No,
there.
that submission has been made already. 451.
Filed on 28th of October. किसका है? प्रोटेक्ट ग्रैंड का है। Lordship got it.
It is not there.
It is not there. In the first half,
First of which page you referred?
page Lordship 462 and 451.
Filing section of covered lots. You have a copy of that?
Yes, yes.
Also, you referred to it, actually annexure, additional affidavit two.
By mistake, Lordship, it is written as a additional affidavit 2, but it is
No, the
filing date is 28
The
October.
pagination would show.
451. Starting testimony, sir.
Section of the lower house. You have an extra copy.
Lordship, may I please to come page 462.
Yes.
462 page.
In the first half, this document I have perused.
Yes. 462, your Lordship, may be pleased to peruse that this is a letter dated 15th of January 2015 in respect of, in the second line, your Lordship, protect grant. Here, there are only 3 signatories. But see, your Lordship, may please to come to page 451.
No, their submission is different. Their submission is that there was an earlier authorization for Mr. Jalan to operate the bank account, and
No, no,
in
that is
in
correct.
that
I am admitting that earlier authority was given to Manoj Jalan.
and because of the court's order, bank is continuing with the earlier authorization. That is this,
Subsequently, that
that
authority
is
has-
what has been submitted.
Now, here I want to prove the fraud committed by the bank in collusion with Manoj Jalan Lordship. The page 462 is dated 15/1/2025 in respect of Protect Grant. Second line of the, having only 3 signatures, Lordship. But Lordship may please to come to page 451 in respect of same Protect Grant. Lordship, dated same date, 15 January 25. It is having signatures of 1, 2, 3, 4, 5
Whether your signatures are also there.
no. My signatures are not.
So others are not disputing.
My lord, here what happened, my lord, when we received the reminders here, these are the incomplete document they have submitted. So we told them repeatedly that you just come and complete the document, because these are 3 signatures only. We need the signature of all the partners here. So subsequently, when we issued this letter, my lord, this 26/9/25, my lord, that is in this third affidavit, my lord, annexure G, my lord, is page 435. Page 435, my lord, annexure G. It was clearly mentioned, mode of operation letter to be signed by all partners as per latest deed. Bank has offered this letter to all the parties, that these are signatures which are pending. So their partners have come, whoever, they have signed. He has not signed. So again, it is incomplete, my lord. Bank is not going to act upon this letter because it is incomplete document, my lord.
You are acting upon the original.
We are acting upon the original one.
Original
Then
one.
at the time of opening of the account, This is an incomplete document bank has.
Because bank has not acted on this authorization because it does not contain your signature.
Yes. In that, what will be the consequences here? The obligation of the bank will be to immediately suspend the operation of the
But there
bank.
is a court order.
Court order is lordship to in respect of the Pride Realty. Pride Realty is not a party in the present suit. That is a separate proceeding under section 9 of the advertisement. Pride Realty is not a party, lordship. So that will not applicable here. Pride Realty is not a party.
Just to clarify, this operates in respect of all the companies.
Section 9 order.
And prayer is also in the section 9 petition, prayer is confined to only one account of the Pride Realty, not for others account.
Your submission is that that order is pertaining to only
Pride Realty.
Pride
Yes,
Realty.
that is the prayer in the petition and that is the court injunction order also. It is confined only to Pride Realty account. So bank has failed to fulfill its obligation, duty lordship,
Okay,
for not suspending the account. Due to-
okay.
Since last
In
11
reply, you cannot repeat the submissions which you have already made.
yes, just to,
My lord, at page 171 of this order, my lord, the injunction order, the section 9, there is clearly mentioned that all sister concerns.
I'll verify. Okay,
only one account, bank account number has been given in the section 9 petition lordship that relates to Pride Realty.
anything else?
I would like to give reply to the submission made by my learned friend, Mr. Dekka.
Yes,
I would like to place one thing in the record, my lord. The second affidavit they filed, they have issued a legal notice to the bank, my lord. The allegations are raised, this. So to that, we have issued already reply to them, my lord, legal notice.
yes, Mr. Roy.
Yes. My learned friend has submitted that in the plain, the companies are the party. And no, there is no board resolution. Lordship is aware that when the plaintiff as a company file the suit, then the board resolution will be required under section 179 of the Companies Act, New Companies Act, Lordship. And here the company is in the plaintiff, your lordship will find the defendants company, they are defendants, not the plaintiff. So there is no board resolution is required. Board resolution will be required by the defendants when it will file their WS or objection. Plaintiff is not supposed to file any board resolution when again for the defendants, your lordship. Lordship, please to peruse the plaint. It is in the plaint. Page. Flag 1. Lordship, may please to come to the page 26 of the file. Page 26, Lordship, plaintiff number is
Yes.
Protect Housing Partnership Firm. 2 is the Lokesh Anand Singhal, one of the partners. Number 3 is Shilpi Alan, who is the mother of the plaintiff number 2. Then Lordship, Protect Grant, it is also a partnership firm. Pro Realty is a partnership firm. Protect Planners is a partnership firm. And then
Before-
Prime Promotion.
Just one query, Mr. Dekka. You have submitted your written objection in IA or?
Yeah.
In the IA you have filed. Okay. That also contains your stand.
That's more form of a preliminary objection highlighting.
Okay.
Actually, we have not really traversed the entire.
Okay. Yes,
So Lordship, none of the companies are the plaintiffs in the plaint. Now your Lordship may come to page 30, where the defendants are shown. Defendant number 1 is the bank, defendant number 2 is the your Lordship regional office of the bank. Then defendant number 3 is Manoj Kumar Jalan, defendant number 4 is Vivek Jalan, Aerocity, Bilker, they are all from plaintiff number 5 to 8 lordship. They are the company, they are the defendant. Why the plaintiff should file a board resolution? So that submission has no force at all. Then lordship. Regarding my learned friend has submitted that there is a MU and in the suit they have filed, the respondent has filed an application under section 8 of the arbitration. It means lordship, clearly it means that they are not abiding by the MU dated 23rd of September 24. Because if they would have abided by the MU dated 23rd September 24 lordship, and then in that event, they would have not filed an application under section 8. In that suit, we have filed an application, our objection against the petition filed under section 8 of your lordship. So that plea is also not tenable. The fourth submission of my learned friend that the suit is not maintainable because MU has to be enforced under section 36 of the Arbitration Act lordship. MU lordship, when MU, if any party defy your honor, but then only the section 34 application is filed lordship, execution petition lordship. Here they have suppressed the facts about the MU lordship, totally suppressed, and the other submission was this lordship. First of all, lordship, my learned friend Mr. Deka has submitted that the first day account was freeze on the application filed by the appellant and thereafter defreeze. Why defreeze, lordship? Because MU was executed. Due to MU, the appellants had the impression that everything will go peacefully and both the parties will act as per the clauses contained in the MU. That's why again application was submitted for regularizing the account, bank account. But thereafter also the respondent did not act as per the MU lordship. And the lordship, may we please to come to this is IA. Pick up the IA page. Page 143, Lord, Annexure 22 of the IA.
Yes.
This is the letter dated lordship 18/5/24 addressed to the bank lordship. In continuation of our earlier email and correspondence and in reference to the caption email as stated above, we hereby confirm that Mr. Manoj Kumar Jalan, partner Pride Realty, is the authorized signatory for the operation of the aforesaid account with your bank. So only in respect of Pride Realty, which has filed the section 9 petition lordship, this letter was given your lordship, lordship. Hence you are requested to decrease the above mentioned account immediately in the interest of the smooth operation of the business of the firm. Then lordship, thereafter lordship, page 146 is the MU lordship after 4 months. Then lordship, lordship, may please to come to page 149, annexure 26. This was given by the builder lordship to the bank on 10/10/12/24. Your lordship may be come to, please to come to next page, page 150, Lordship, last para. I request you to order for a review and audit of all the signatories KYC to be redone of all bank accounts to reassign the check signing authority. This is very important with all respective partners in partnership firm as per partnership agreement and directors in the company. And once you see that not all signatories are on the same page, it will reveal as what is going on. You can then only please freeze the respective bank accounts until further investigation by the authority. This will stop further unauthorized activity and more importantly misuse or diversion of the group's fund had earned money of the home buyers, which otherwise may add to the already critical situation. So this letter was given by the appellant petitioner law. Even then, the bank did not acted law. Neither accounts were not suspended, and the still till date, Manoj Jalan has been withdrawing his money, Lordship. Then, Lordship, the next submission. My learned friend, Mr. Dekar, submitted that all the partnership deeds are having the arbitration. I am not denying that. It's correct. All the partnership deeds are having the arbitration. That's why, Lordship, the matter was conciliated through the MEU dated 23rd of September 24, Lordship. So once that chapter, that is thereafter, when the MEU was executed by both the parties, Lordship, that arbitration clause in the partnership deed will not be able to act as per the MEU, Lordship. And limitation, Lordship, the section 9, Lordship, be pleased to take up the section. Section 34, Lord. Section 34, subsection 3 of the Arbitration Act, Lord. An application for setting aside may not be made after 3 months have elapsed from the date on which the party making that application had received the arbitral award, or if a request has been made under section 33 from the date on which that request has been disposed of by the arbitrator, provided that if the court is satisfied that the application was prevented by sufficient cause from making the application within the said period of 3 months, it may entertain the application with a further period of 30 days, but not thereafter. So, Lordship, within this 30-day period, nothing was done by the respondents, Lordship.
This plea you can take in 305 or
Pardon?
2. They have arbitration case number
Under section 9.
205, yes.
Oh.
There is a bar of limitation.
That is correct, that we have already taken there. We have filed our objection also, Lordship. And tomorrow it is fixed for hearing. My submission is this, Lordship, the suppression of material facts is a very serious thing. There is a leading Supreme Court decision, Lordship. If there is a suppression, nothing other things can be looked into in case of suppression and fraud. Suppression and fraud leaves everything behind. Why filing the petition, when filing the petition under the line of the way, why they suppress the fact, such a material fact, when the matter was already arbitrated? Lordship, this citation is, Lordship, 2025 INSC page 348, Lordship, para 9. Para 9. Para 9, Lordship.
Your submission is that while preferring application under section 9, they suppress the fact of existence of a MOU. That is your submission.
That is submission, because you are while intentionally or willfully they suppress. If lordship, if the question of execution of the MU dated 23rd September 24 would have been mentioned in the petition file under section 9, then certainly the bank, the learned court would have thrown the application or dismiss outright lordship. When the matter is already arbitrated petition, the section 9 is, what is it? Privilege stay before initiation of the arbitral tribunal proceeding lordship. Here, para 9 I am reading. It is no more less integra that the doctrine of the clean hands and non-suppression of the material facts is applicable with full force for every proceeding before any judicial forum. The party invoking extraordinary jurisdiction of the High Court under Article 2 to 6 of the Constitution of India must come with clean hands and disclose all correct and material facts in his petition. It is if it is brought to the notice of the court that the petitioner has been guilty of suppressing the material fact and the relevant facts, or has not come with the clean hand, such conduct must be seriously viewed by the court as the abuse of process of law, and the petition must be dismissed on that ground alone without catering into entering into the merit of the case. So, lordship, this is the, and there is also one other judgment of the apex court on the same point, suppression of material fact. Lordship citation is 2004 5 SCC 485. Next judgment, lordship, para 13. Relevant. Para 13, lordship. Lordship got it.
Okay. No, I agree to your submission that if there is a suppression of material fact, they are not entitled to any relief. So your submission is that they ought not to have got any relief in the arbitration case.
Yes.
That is your submission.
That is a fraud committed by the respondents upon the court by suppressing the MU. Fraud with the court, fraud with the present appellants. Lordship. वही तो मैं बोल रहा हूँ। Lordship, my learned friend has submitted regarding the jurisdiction of the trial court lordship. So I would like to place one judgment of the apex court lordship. This is by the constitutional bench lordship. The citation is lordship 2024 4 SCC 696. Page 145 of the judgment bunch of the judgment. The earlier judgment said.
Yes.
Page 140.
Yes.
Yes, Lordship, may you please to come to page 167, para 39. Although not directly arising in the present case, we also wish to observe that the question of the jurisdiction would assume importance even at the stage of a court consider the question of grant of interim relief, where interim relief is claimed in a suit before a civil court, and the party to be affected by grant of such relief or any other party to the suit raises a point of maintainability thereof, or that it is barred by law, and also contends on that basis that the interim relief should not be granted. Grant of relief in whatever form, if at all, ought to be preceded by formation and recording of the at least a prima facie satisfaction that the suit is maintainable or that it is not barred by the law. In the present suit, there is no such finding by the learned trial court that the suit is barred or not maintainable. So this question cannot be raised before this honorable court. Then your honor may come to the bottom side, relevant portion. However, if an extraordinary situation arises where where it could take to decide the point of maintainability of the suit and non-grant of protection pro tem pending such a decision could lead to irreversible consequences. The court may proceed to make an appropriate order in the manner indicated above, justifying the course of action it adopt. In other words, such an order may be passed if at all required to avoid irreparable harm or injury or under hardship to the party claiming the relief and or ensure that the proceedings are not rendered infructuous by reason of non-interference by the court. So the learned trial court gave the finding that there is a prima facie case. But regarding the irreparable loss and injury, the learned trial, what finding has been given? That the third party will be affected. But the third party is not the party in the source. Those things are the perversity writ large on the face of the record. So that submission of my learned parent is also not tenable, then Lordship. My learned friend has submitted that if an injunction order is granted by this honorable court, that will be in contradictory to the ex parte injunction order granted under petition filed under section 9 of the arbitration.
Yes.
Cannot be your honor, because Pride Realty, which has filed the petition under section 9 of the arbitration, is not a party here. Lordship, in the present suit, Lord, that is not a party. And in the petition under section 9 of the arbitration, only one account number has been given that relates to only Pride Realty Partnership, which is not a party in the present suit. So that plea is also not tenable. None already have submitted. And no, there is no court order, Lordship, that the only Manoj Jalan will be the authorized signatory, Lordship. I have submitted the judgment before Lordship in the first half, where is the Supreme Court let down the line. Any partner can stop the transaction of the bank account. And bank is bound to do so. And Lordship, plaint में है क्या? Your Lordship, may you please to peruse this page 83 of the IR Lordship regarding the which deals with all the clauses of the Partnership Act. Page 83 of the IR. आराम समझिए, तुम ज्यादा लेक्चर में page 83.
Yes.
In all the partnership deed, Lordship, if this is in respect of Protect Housing, clause number 4, that the new partner shall have right to operate the bank account together with other partners, but with consent of all other partners. The relevant portion is Lordship is page 87. Clause demand.
Yes, 87, I got it.
Clause 4. Oh, page 87. Page 87, sorry. Page 87. That the new partner shall have right to operate bank account together with the other partners, but with consent of all the partners. Then 5, your Lordship, clause number 5. That the said partnership between the continuing partners and the new partners will continue thereafter on the same terms and conditions as are contained in the said original deed of partnership, other than items herein altered or mentioned. So, Lordship, when in all the partnership deed, Lordship, there are similar clauses, Lordship. in all the partnership deeds. So your lordship, a partner, and as per the Partnership Act, lordship, a partner cannot be restrained from participating into day-to-day affairs of the firm's lordship. I have quoted the provisions of the Partnership Act also, lordship, in the, that is, it page, lordship. Page kitna hai? Lordship, may please to peruse section 9 of the Partnership Act. Partnership Act, you know.
Ramesh. Partnership. Act. Yes, you read.
Then I am happy. Section 9, lordship. General duties of the partners. Partners are bound to carry on the business of the firm to the greatest common advantage, to be just and faithful to each other, and to render true accounts and full information of all things affecting the firm to any partner or his legal representative. Section 11. Determination of the rights and duties of the partner by contract between the partners, agreement in restraint of trade. Subject to the provisions of this act, the mutual rights and duties of the partnership partners of a firm may be determined by the contract between the partners, and such contract may be expressed or may be implied by a course of dealing. Such contract may be varied by consent of all the partners, and such consent may be expressed or may be implied by a course of dealing. Conduct of business, section 12. Every partner has a right to take part in the
No,
business.
what you want to emphasize?
Lordship, I have
before
a
reading.
restraint by lordship from taking part in the affairs of
So
the
that is,
par-
your submission is that is contrary to the provisions of Partnership Act. That is your submission.
because I am not allowed to participate in the business day-to-day affairs of the partnership firm, lordship. And due to bank intervention, due to collusion between the bank and the private respondents, lordship.
Yes.
Lordship, may please to peruse the
Now you will go through entire Partnership Act.
right. Your lordship will peruse.
You have made your
Your lordship
submission.
knows regarding the provision. All partners have equal right to participate. All partners have equal right to sign the bank document, and bank is bound to share the document with the partners, lordship. Those are the provisions. I have already submitted. We are majority shareholder, 70%. In all the partnership deeds, your lordship will find that we are having 70% share
No,
in the loss and
okay,
profit.
okay, you have replied. Only
Yes,
one query. The petition by learned counsel for the private respondents, Mr. Deka, was that the dispute is not between two families. It is only between two members of single family who are the
No, two members of single family, that is a.
other members.
No, that is a different matter, lordship. Here, family is a single family and Jalan family. Manoj Jalan, so his title is Jalan, so single family, Manoj Jalan. He has intised away the younger brother of the petitioner number 2, lordship. And he is also playing with Manoj Jalan. That is this, earlier it was not there. Whatever it might be, the rights and duties will be governed by the Partnership Act, read with the provisions contained in the partnership deeds,
Okay.
lordship. And bank is bound to act as per the Partnership Act, partnership deeds, and as per the RBI guidelines, KIC directions, your lordship. Bank is not doing. Collusion is apparently on. The bank has put expose itself, lordship, by not suspending the account. But for the benefit of the business lordship, I also
You are
already.
not praying for
in-
suspension.
For the larger interest of the business lordship, I don't want that the bank account should be free. Only what is that Manoj Jalan may authorize, represent all other partners. I have no objection, but my signature should be there. I have a right under the partnership act. I have a right under the partnership deed. Lordship, see the actions of the bank.
No, no, okay.
Sometimes the bank recognize me as a partner, sometimes say, no, you are not the partner. See the fraudulent act of the bank, Lordship. Lordship, may we please to come to IN, page 156 of the IN. How the bank is functioning. 156, annexure 28. This is a letter by the bank dated 16/5/24. Okay, need this before. Your Lordship, this in respect of Protect Buildcon Lordship, the bank has stated that I am not the authorized. That I am the, sorry, I am the authorized signatory. Then your Lordship, in column number, in case of for column 1, 2, 3, 4, 5, 4 and 5 Lordship, debt free.
Bank is again recognizing me as a partner.
The bank is again recognizing the present petition number 2 as the partners, Lordship. Then, and then in the last 2 columns also,
This letter will-
recognize for all the entities that Lokesh Singhal is the authorized signature. नहीं, वो जिसमें नहीं माना वो जिसमें नहीं माना जब मैं बोलता हूँ निकालना है तुम तो अपना उत्तर दे। Then your Lordship, may please to come to page 154. This is the letter by the bank. The letter starts from page 153, Lordship, date 13/12/24. Next, after 6 months, Lordship, see the fraudulent action on the part of the bank. Second, page 154, second para. With respect to the other accounts of the Protect Group companies and the partnership firm, as per bank record, you are neither authorized signatory, not a partner in the respective accounts of the Protect Group companies and partnership firm. Hence, your request for making debit free in the said account cannot be acceded unless you provide us appropriate instruction from the statutory authorized or a court order. See the conduct of the bank. Whereas as per the documents, Lordship, so this is a fit case, Lordship, to allow the appeal and to grant.
Yes. Heard Mr. SP Roy, learned counsel.
Yeah, that's one. नहीं देगा।
Also heard Mr. BD Dekar, learned counsel for, no, also heard Mr. AK Gogoi, learned counsel for respondent number 1 and 2, as well as Mr. BD Dekar, learned counsel for respondent number 3, 5, 6, 7, and 8. In the next week, let this case be listed for delivery of orders on 7th of. If I get any difficulty in disposing of the main case, then I may come back again. I'll try to dispose it off on 7th. Means
November.
7th November, next Friday.
Lordship, I am having one item number 5. I am not the advocate, Mr. Kalpana Yadav is,
This is not the way, madam.
she has.
This is not the way, madam.
No, no. Just
Well, he is not the council, I am the council in the item number 5.
What I have submitted, Lordship, she has.
let me come out of this protect group first.
Okay.
Malad, the only thing is this is the 14 years of second appeal pending. And my lord, my client is in the dead bed in the hospital
Oh.
and calling me every day why the case is not been
This
listed.
is,
The
this-
counsel for the.
this
appellate-
mentioning is in respect of which item?
Item number 5, malad, suddenly my friend
Next
has
item.
started mentioning.
No, I'll hear you. Let the matter be, yes.
Uh,
This is fixed.
I don't know
Let
if
this
Ms.
matter be
Kalpana
listed
Yadav
on,
is the advocate.
just a minute.
Sorry.
Let this matter be listed for delivery of orders on 7th of November, 7th November. Yes, item number 5. Now what is this?
Well, yes, I am for the, second appeal pending from 2011 with the stay order. I am the plaintiff. I am suffering. Malad, they just Ramlal Jadhav, Kalpana Jadhav, I have heard of that Mrs. Jadhav is some medical ground is there. Ramlal Jadhav was there. He was arguing the
No, no,
matter.
he's also in a serious condition.
Then Malad, to a certain extent, my patient is also, client is also in the dead bed.
Major surgical operation of the hip joint has been done. to
Ramlal Jadhav is there.
And what my
Anand
learned
Jadhav
friend
is
is
there.
objecting. He should not object on humanitarian ground.
Malad, when the other councils are there, 14 years a second appeal
have
pending,
cases
Malad.
junior.
Suit of 2007. But I am the plaintiff, I am suffering, obtaining a stay order and 14 years. Well, because my names are not shown, Malad, counsel for N. Devnath, somehow, Malad, it has been. So, Malad, I'm giving a chance, but on next Thursday, Malad, I need this disposal, man. There will be no more chances, man.
No, no, you cannot fix, cannot dictate the court to fix.
Malad, they will again take time.
But can you dictate the
No,
court to?
the court, Malad, my friend will again, the last chance, Malad. I'm waiting for this case, Malad. because
Yes, if the council has some difficulty,
Council.
then you have to engage another on the
Councils.
ground of difficulty of the council. Continuous adjournments cannot be granted. On 1 or 2 occasions, that may be justified. But if the reason is going to persist for long, you have to change your council.
So there, Ramlal Jadhav and Kalpana Jadhav. Kalpana Jadhav has a medical problem. Ramlal Jadhav is there, my lord. He was arguing the matter. He could come and argue the matter.
No, he is also suffering from serious heart ailment.
Okay,
Lord.
we'll.
Surgery. His
So
valve has-
what is your submission?
Well, this will be taken after second week of December.
No, my lord. 2nd of December, vacation will come.
Lordship,
It will go to
both her wife and husband, they are on bed.
My lord, I'm also, my client is also in the dead bed. He
Leave
wants the case to be solved,
leave
my lord,
application has been also
before
filed.
he expires.
Hmm.
My client is also in the dead bed, my lord. He is, the wife is calling me upon and saying that, my lord, at least the case should be disposed of. 14 years in the High Court, my lord.
3rd week of November.
Date may be fixed, my lord. I just folded and my lord.
No. You listen to the order.
Hmm.
Heard Mr. S.P. Roy submitting on behalf of Mr.
Kalpana.
Ms. K. Yadav. Also heard Mr. P.K. Roy Chaudhary, learned. Ms. K. Yadav, learned counsel for the appellant. Also heard Mr. P.K. Roy Chaudhary, learned counsel for the respondent. Learned Mr. S.P. Roy submits that he has been instructed by the engaged counsel for the appellant to seek an adjournment on the ground that she is indisposed and have undergone a hip surgery. On the other hand, learned counsel for the respondent has opposed the grant of and opposed the prayer for adjournment pleading that this regular second appeal is of the year
2011.
2011 and considering the long pendency of this case, further adjournment may not be granted. I have considered the submissions made by learned counsel for both sides. Considering the submission of learned counsel for the appellant, as well as considering the fact that otherwise also today there is paucity of time. This matter is adjourned for the day. Let it be listed on a day to be fixed. In the fourth week of November. Let it be fixed in the fourth week of November on a day to be fixed by registry.
Public.
Number 8.
Ramesh Yadji, Protekor Ji Asilim. Citations, separate file of citations. In a separate file.
May I place your lordship?
Yes,
Lordship, my senior just left because due to the difficulties. So
what difficulty?
like he has to go somewhere, like there's an urgent matter, urgent work, personal work, so he has to leave. So I sought for another time, for another day.
Yes. Any objection?
Kindly, your lordship may fix a date.
No, fixing date is difficult.
So, your lordship, because on 4/10/2023, there is an order of early hearing. We prayed for early hearing.
Okay.
That's why.
Then we'll fix a date.
That's why. Your lordship.
Heard. Item number 10. Heard. What is your name?
K. Kharbani on behalf
Heard
of.
Miss A. Kharbani, Learned Council for Yeah. Learned Council for respondent. Learned Council for appellant. Also heard Miss
That's all.
S. Paul, Learned Council for respondent number 1. Learned Council for the appellant has prayed for an adjournment on the ground of personal difficulty of the conducting counsel for the appellant. On the other hand, Learned Counsel for the respondent submits that as there is an order of the court for expeditious hearing of this appeal, a date may be fixed even if the adjournment is granted. Stop considering the submissions made by Learned Counsel for both sides. Let this matter be listed again on when 20th of November, list accordingly.
Highly
Much-
obliged.
My lord, reversal of judgment and decree. That's why this second appeal. But if it is due to paucity of time, your lordship will take other day. My learned friend of other side is here.
It will take some time. It's up to lordship. Lordship, we can either you can start then spill over some other day, or lordship will take
No spilling over. After a long hearing, again, if I keep the matter part heard,
it will some other day. It's up to lordship.
All right, on the 7th or 13th.
No, 13th
Because
to 7th. 13th to 7th, there is some difficulty with it.
Then thereafter on 18th.
on
Can
18th,
even
We have early hearing petition that
18th,
18th.
Mr. Datta,
Can it be 20th, my lord? Sorry.
20, I am engaged in other court.
Another matter has been fixed on 18th, that's the thing. Or 25th.
Oh, then I have only 27, no other day. On 27th, I can make it.
okay. This is item number 11.
11.
Heard Mr. What is your name?
R Islam.
Heard Mr. R. Islam, Learned Counsel for the appellant. Also heard Mr. M. Datta, Learned Counsel for the respondent. This matter could not be taken up for hearing today due to paucity of time. Stop. Let this matter be listed on
7th.
27th of
That's a hearing. to
November,
third-
yes,
third-
that's a hearing.
27th of
November.
November as a fixed item.
Oblige.
Oblige.
MSc appeal, it was listed day before yesterday, the lawsuit is today. I think today will not be possible. Make,
MEC appeal for what matter?
my lord,
IAs are there.
my lord, eyes are there,
But it is not pressed, my lord.
I have not placed. Painting order is there. But here in the case, the claim petition was dismissed because they filed in 166. But 166 MVI and there is a section of 302.
Let me fix it.
Let me. Court is acting now.
Let me be fixed since the matter will not be, time will not be permit.
Suggested it.
That is
Fourth of first within a hour.
November, my lord. So it will be convenient for your lordship.
The first
No.
item,
4 तारीख से auction के लिए
as a first item, if it is possible, but
It is listed around 20 times.
maybe. Because paucity of the time of the court.
But I have paucity of time unable to.
But his difficulty, sometimes my difficulty.
Because you have seen the first item today.
Yes.
My lord.
Today, one matter took the
Yes,
entire
yes,
day.
yes. That is, although we are present here.
You, 4 तारीख है.
I
Heard
think it-
Mr. R.C. Paul, learned counsel for the appellant. Also heard Mr. I.A. Talukdar, learned counsel for respondents. This matter could not be taken up for hearing today due to paucity of time. Let this matter be listed on.
Fourth.
Okay, on 4th of November.
No, much obliged.
14.
My lord. This may be adjourned for 1 week, my lord. Due to some personal concerns.
Who is for other side?
This Union of India, my lord.
Heard Mr. What is your name?
A Gohai.
Heard Mr. A. Gohai, learned counsel for the appellant. None has appeared for the respondent side. Stop. Otherwise also, due to paucity of time, this matter would not be taken up for hearing. Let this matter be listed in the 3rd week of November.
Date may be fixed on next week, my lord.
3rd week of November on a date to be fixed by registry. You are there?
14 lordship.
Yes, 14.
Mr. Harish Gupta lordship has been engaged in this matter very recently, lordship.
You are appearing for?
Mr. H Gupta lordship. Yes.
Also heard Miss, none appears to Katidibo. Heard Mr.
Why Borbuya lordship?
Y. Borbhuya appearing on behalf of Mr.
H Gupta lordship.
H. Gupta, learned Central Government Council. Baki, due to paucity of time, 3rd week of November. Last item, Nikki, was.
Lordship, in this case, I have some urgency because Lordship, since last more than 1 year, 1.5 year, Lordship, my client has not received a single amount from
This is matrimonial matter.
Lordship. So may I pray, Lordship, on next Tuesday, Lordship? 10,000 maintenance, Lordship, interim maintenance, that is not paid for last more than 1
Why
year.
are you not paying?
There is stay order also, Lordship.
Actually, your lordship, the respondent have played fraud upon the petitioner and on the court also by filing a fraudulent affidavit, your lordship. That is the ground on which.
That is a merit, Lordship, but first an order to pay rupees 10,000 per month and 30,000 litigation cost. That was not paid since last August, Lordship. That's why, Lordship, I have some,
Divorce case is pending.
yes, Lordship, divorce cases pending.
Moreover, lordship, my income and expenditure statement was not considered in right perspective. your lordship.
How old are petitioner and respondent? What is the age? Is there any possibility of compromise? Since when they are remaining
34 years, Lordship.
34? Husband?
43. He is serving lordship as a branch manager at Aditya Birla Health Insurance Company lordship, and his monthly income lordship in his statement lordship before the court is that 65,965 lordship.
That's right, but then my expenditure is also 65,000.
So how it is lordship? And after marriage lordship, he has some responsibility to me lordship.
Don't have any issue,
Child also has.
no issue
One child is there, he is with,
with the father.
I have no income lordship.
Taxi is not willing to take care of the child. also.
It is
No,
different.
can they appear in the court in person on the next day? Then at least we can have a try. Heard Mr. R. Sharma, learned counsel for the petitioner. Also heard Ms. P. Bhattacharjee, learned counsel for the respondent. This matter could not be taken up today due to paucity of time. However, considering the materials available before the court, as well as submissions made by the party, an effort may be made by this court to see as to whether the matter may be amicably settled between the parties. Accordingly, both the parties are directed to appear before this court in person when will be convenient.
Until November, mid-November. Your Lordship. Not on 10 and 11 and 20.
Then on 18 lordship, Tuesday, hearing day.
13,
13.
13,
30.
13. Let this matter be listed again on 13th. We'll make one try. And during that,
That is better lordship. for
during
both of
that, this question of this matter may also be taken up regarding payment of 13th.
That will better for both of them lordship.
13 at 1 p.m.
Obliged.
16, none appear. 16, anybody is there? None appears for the parties on call. Let this matter be listed in after 2 weeks on a date to be fixed by the district.